Yes. Senior Vice.
With the leave of my Lord Justice Day, my Lord, may I have my Lord's kind leave to mention a matter. It's a review of the Lordship, my Lord, sitting with Honorable Justice Vishwarup Bhattacharya. But any day next week or the week, whenever the business permits.
Whenever
whenever the
we'll have a
business
talk.
permits, there's urgency, my Lord, kindly. I'm mentioning upon.
May I have your lordship's leave to mention item number 187 and 188 of your lordship's list, my lord? Yes. These are appeals against ex parte ad interim orders passed by City Civil Court without jurisdiction, my lord. The urgency is, my lord, what is happening, my lord? Order 41. Order 41, we fix days for order 41 and definitely we'll reach it. But it will take some time. Not tomorrow. Tomorrow is a holiday. Holiday, my lord. Thursday, Friday won't be possible. Monday will be taking these up first. Because the reason is, my lord, I am running a co-working space. They are using this order and pasting it in all. We'll take it. Yes. Very good. Order 40. Yes. Please.
My lord, this is an appeal against ex parte order. My lord, the execution proceeding is already in process, my lord. The next date is fixed on 5th September 2026, my lord.
This is the first appeal.
Yes, my lord.
Which year?
My lord, 2025. This is against an ex parte order, my lord. My
Ex
lord,
parte order doesn't make a difference.
my lord, if the execution is already
Hand over this.
my lord.
Call go. My lordship. No father. One who is appeal. Yes. Yes, you are. You had finished.
And yes, on last occasion, a query fell from your lordships as regards the rule cited by my learned senior friend.
Or central government applicable or not?
Yes.
In the rule, Lordship, the central government
Thank you.
is applicable,
Yes.
Lordship. The rules of all the central government is applicable, Lordship. Lordship, Rule 30, Lordship.
Sure.
Paragraph 30.
Achha.
Paragraph 30, I flag, Lordship, flag.
Oh, achha. Thank you.
Paragraph 30, Lordship, Rule 30. But you asked me the whether central government
I've got an extra copy for him, otherwise you.
No, my lord, I had submitted this on last day.
Achha.
Rule 30. My,
this submitted.
So you have a copy?
I don't have the entire copy, just have the rule 30, my lord, I have.
Okay, no problem.
Just remind us, Mr. Chakraborty, the brief facts.
The fact was this person, my lord, was handed with an order dated 23rd April 2003 saying that he has been deemed to have resigned from service. The argument sought to be made out here in this case is that the power to invoke that provision, my lord, was not available with the respondents because that provision in CCS rule was added in 2012
Achha.
and the order was issued in 2003. Also, there was this issue of whether the director was competent to issue this order, my lord. I had relied upon a circular, my lord, of their institution, appendix. It's a schedule made available in their website, from where it is seen that the appointing authority of the scientist, my lord, is not the director, but an authority superior to the director. These were the issues, my lord. And since I had brought up this point that provision of deemed resignation was not available, my learned senior friend has relied upon All India Service Leave rules.
What is the answer to this? 30?
I have relied upon 30, my lord. I am saying that CCS rules are applicable to me.
Okay.
If my lord kindly takes up Rule 31, my lord.
Yes.
31. Any inverted provision?
Page 35.
And there's a heading service conditions.
These are your bylaws.
These are the bylaws of this institution.
ICR, the Indian Council of Agriculture Research.
Kindly see Rule
All
31,
India.
my lord.
31, yes.
31
30 first and then we'll come to 31.
Yes.
Except in your rules. Except where rules are specifically made. Then central rules should be added. Now 31.
Now
yeah?
31. 31 says Central Civil Services CCA rules and Central Civil Service Conduct Rules of the Government of India for the time being in force shall apply so far as may be to the employees of the society, subject to certain modifications. That president and government will be replaced by terms president of the society and officers and employees
Yes.
respectively and all that.
So therefore, there is a specific provision. Therefore, residuary clause of 30 does not apply.
Yes,
The 30 says
all.
except in regard to matters for which specific provision
My
has
lord,
been
so
made.
even if my lord kindly takes volume 2 of the writ petition, my lord,
Yes.
once. And if my lord kindly turns to page 246. Volume 2, my lord, 246.
Yeah. 246. You have not given the first page of this.
My lord,
Not
pardon.
given the first page, it's from the middle, from 5.
Page 246, my lord.
246, yes.
Yes. And rule 7 is quoted over there, maximum period.
No, it starts from rule 5. That's what we're
Yes, yes, yes. My lord, this is,
First page you have not
my
given
lord, this forms a part of their reply to our rejoinder, my lord.
This is
in
the
the-
part of which rules?
This is the part of All India Civil Service Rule, which my learned senior friend is relying upon. This is an annexure, my lord, to their reply filed to the rejoinder of the applicant in the original application.
Yes.
Now, kindly see is Rule 7.
7.
My lord, no member of the service shall be granted leave of any kind for a continuous period exceeding 5 years. Sub-rule 2, a member of the service shall be deemed to have resigned from the service if he, my lord, without reading the conditions, my lord, kindly see footnote 4. The annotation is there, my lord, footnote 4, my lord. Substituted by.
Yes.
Substituted by DO and T notification number such and such, dated 19th October 2004. This again, my lord, is subsequent to the order of deemed resignation passed in my case. So even if by relying upon Rule 30, it is contended that All India Service Rule is applicable to me, even then, my lord, they cannot rely upon Rule 7. And my lord, relatedly, if my lord kindly turns to page 227, my lord. My lord, kindly see 227.
Yes.
Kindly see paragraph 4, my lord. As per the All India Service Leave Rules 1955, hereinafter referred to as Rule 1955, my lord, maximum period of absence from duty. This is the provision which they have annexed to the rejoinder we have just,
The amended provision.
shown. Yes.
Amended provision.
Yes,
If
amended.
after your
Yes.
joining service.
After that order of deemed resignation was passed.
Even after that.
Yes. This is the provision of deemed resignation in All India Service Rule came into effect on 19th October 2004.
Yes.
And the order of deemed resignation in my case was passed in April 2003. Much prior. And my lord, in paragraph 4, they have relied upon All India Service Rules. Kindly see in next page, my lord, they have relied on Rule 26 of CCS rules, which I had shown on last occasion. And Rule 26 says if you resign, then forfeiture of past service. So they have relied upon both these provisions, CCS as well as All India Service. Now, my lords already know this, my lord, that All India Service Rule, my lord, applies to all India services, IPS, IAS,
By
and
default,
these
it applies to
persons, my lord, they are employees of an organization. So they do not belong to a cadre which serves across India, subject to correction. But my lord, even if these rules are applicable, my lord, this provision is not there for them to invoke at that particular time. Also, my lord, I had stated that they had taken a decision, my lord, to rather they were in discussion, my lord, of regarding initiation of a disciplinary proceeding. I had shown page 187, my lord. I ought to have shown 185 and 186 as well. This is also volume 2, my lord.
186.
180, 185 and 186. And kindly comes to 185 first.
180. Yes.
May I place, my lord, reference your communication, my lord, that line. Reference your communication number such and such dated 24th April 2002 and 4th September 2002 respectively. I am directed to inquire about the following facts. Number 1, details of communication between your institute and Dr. Das during his absence of around 11 years in the form of a memorandum, show cause, etc. So the undersecretary writes to the director asking as to whether any show cause or memorandum of charge sheet has been issued against him or not. Admitted position, no charge sheet was issued, neither any show cause. Now kindly comes to page 186, my lord.
Disciplinary action was not taken in your case.
No. My lord, kindly see, my lord, second paragraph. I am directed to request.
Saw that.
Yes. And then I had shown 187 where there is a legal opinion, my lord, asking that immediately a show cause or a memorandum of charge sheet must be issued, which is at page 187. I had shown this on last occasion, my lord. But these two pages ought to have been shown as well. My lord, this Dr. Dhurjyoti Prasad, my lord, the father and husband of the petitioners, he passed away in 2022, 17 January 2022. Thereafter, these petitioners have been substituted. So they are asking for family pension. That is their prayer. Salary I cannot demand because he did not work. It is not established that he worked for that organization.
Daisnon was probably previously informed.
Previously, in case of a separate infraction, my lord, Daisnon was imposed.
But not regarding this.
Not regarding.
Here there is no scope because he did not actually work for that. So let us go on to your last point. Yes, yes, sir. What is your?
Lordship, this is the fifth round of litigation, Lordship. First round, Lordship, his fathers or husband raised before 94, before come High Court, then withdraw, then go to CAT. And 94 again withdraw some defect in the petition application, Lordship. Then again 96, he filed one application before the Central Administrative Tribunal. And that in the Central Administrative Tribunal held that he is not, dies in none is justified. He is not entitled for anything back wages, and Lordship, not the past service. He is not entitled for any past service benefit. Lordship, this is the 96 case, Lordship. Then he approached this Honorable High Court. This 189 by 2006, he approached this High Court, and division bench of this Honorable High Court, presided by Justice Girish Chandra Gupta, has been pleased to pass order that the tribunal has justified in passing order that dies in none is justified, and also during this period we passed the dies in deemed resignation, that is also justified and not entitled for any back wages. When the Honorable Justice Gupta asked why you are last 10 years, 13 years you're moving in the court, the petitioner husband replied, it is also recorded, that I am doing cases in the High Court in the from 87 till the date of retirement, Lordship, 62 years of retirement, age of scientist, 2010, about 23 years never reported for duty. And the division bench of Lordship held that he is not, three things decided by Justice Honorable Justice Gupta, Lordship. First, Court judgment is justified. Second, dies in justifier, and deemed in resignation is justified. That is also Lordship or no, he is not entitled for any backway. In that, Lordship, he filed, the father of the husband of petitioner filed one review application. That his Lordship in paras page 6 recorded the abandonment of service. His Lordship said that, okay, I will delete this portion only, nothing more. Again, Lordship dispose of.
Which portion? Deemed
In the Lordship.
the deemed resignation portion was deleted.
No, deemed abandonment of service, not deemed resignation. Abandonment, Lordship, his Lordship division bench recorded that he has abandonment the service, that was deleted, nothing more. And review petition was disposed of.
Please show us that portion of Justice Gupta's judgment which says that this deemed resignation is justified.
And my Lordship, that again, my res judicata Lordship, coming Lordship. Lordship, page may 159 may be seen. Lordship, they start. 158 start, Lordship. Beside the above period of unauthorized 91 in this matter, Lordship deal the 91 till 2001, 2010, he never reported for duty. 23 years continuous substance. From to 158 page, Lordship, I have reading.
Justice Gupta asked him, but Justice Prosenjit Mondal delivered the judgment.
Yes, Lordship, give opportunity to everybody.
So that question was, we are not going. Where is the finding, please?
That's a 158 may be seen from start. Beside the above period of unauthorized leave, this petition absented himself from attending office without intimation since 2991 up to the date of filing the application 30 September 1996. Nor did he file any application for leave for regularization of the unauthorized absence. The writ petitioner contention that he was busy in looking after his cases and writ application before the learned tribunal. In the High Court at Calcutta, this is the ridiculous. He is also contended that he was present in the Honorable Court since the month of 92 till the date of filing of reply 2005. He was assisting the proceeding matter, so he should have been deemed to have resigned. He should not be deemed to have been resigned. Next, we find neither the learned tribunal nor the High Court Calcutta asked him not to attend office. Even he also requested to join, but we refuse no. So contention of the writ application that he was busy in looking after the cases, writ application filed by him before the tribunal and the High Court Calcutta cannot be accepted. As such, period of absence cannot be treated as on duty. He was also contended that he joined CM of RI on 96. This is not any institute of ICR. Even the Lordship observed. Single tribunal observed, because not my institute. ICR in India, we have no such institute. But we find that his contention is not supported by any cognizant document. Moreover, as a rival contention, the respondent authority, CFRI, is not at all under the administrative control of the Central Research Institute for Jute and Allied Fiber. Barak, he did not apply any leave, nor did he explain as to why was he unable to attend the service. The conduct of the writ application proved that he had abandoned his service. This portion, Lordship, the review, deleted. This portion deleted. And the last portion, next page, Lordship. because such a unauthorized absence competent authority was hold that within its power to proceed on the basis of his my learned friend said that not posting was initiated. He was 5 times let's see before punished, sometimes censored, sometimes this when before 87 5 times he was punished, not once. That is why let's see the even I say go join, but he not. By last 15 years, I am fighting this matter. Different court, this court, this court. That's it. Again, we hold that fine within authority we hold that within the power of proceeding on the basis of that writ application should be deemed to have resigned from the council service with effect from 29/12/91 by this and this dated letter lordship, and the consequent of such situation and result of wage 1197 or 96 of miscellaneous applications that the respondent authority was also within the competency to issue letter 2005 to the writ applicant intimating that the writ applicant was not entitled to salary for his unauthorized absence from duty, and said period could not be counted towards his past service. This is also lordship. By miscellaneous application 3/11/96, the writ petition is prayed for a fixation of seniority, and this is useless lordship. As the writ application abandoned his service, the question of granting arrears appeared. This is not at all, not arise at all. In view of discussion above, we are viewed that the finding of the Central Administrative Tribunal cannot be said to be perverse without any basis. We are viewed that the learned tribunal has rightly observed the way is benefit of any merit, and the consequently the miscellaneous application this and this should be also dismissed. So the writ application is not entitled for.
So the first part of page 160, we hold authority was within its power to proceed on the basis that writ applicant should be deemed to have resigned from council service with effect from such and such date. And was there any similar finding of the tribunal?
Yes, no, deemed resignation, not
Was not
deemed,
there, but
deemed,
High Court had.
yes, because he challenged the 91, 90 from 87 to 90 he was absented. That was challenged in 94. Even but 91 from in 91, 12, 9, 29, 12, 91 he was absented from duty.
Right.
29, 12 from
So
90.
he is barred by res judicata now from reopening this issue.
Yes, my 100% is recent judgment of Justice Honorable Justice Dipankar Dutta, Supreme Court Lords. I brought the judgment.
The one which deals with Order 9, Rule 9, Order 23.
I am not a CPC Lordship.
No, their lordships were on CPC. Sitting heavily over.
Jolly Lordship, the Goa Lordship judgment recently.
That judgment, Order 9, Rule 9 and Order 23 equated, and also.
No, recently I brought Lordship. Yani.
And constructive res judicata, yes.
Puja Feru Elias Lordship. Division.
You have the SCC online copy, it's reported in SCC online also. No, this is a different judgment. Anyway.
Yesterday night I brought Lordship. Whole night I.
At what time?
12.
After midnight, then it's today. So where is that finding?
Finding that
Which part?
Lordship, I have not gone through full judgment, Lordship.
This is for what proposition?
This is provision for the res judicata. Again, the second Lordship, right or wrong, Justice Division Bench held that deemed resigned not entitled in the
That
first.
is settled. If it's barred by res judicata, why do you cite a judgment for that? Res judicata is well settled.
Some courts say, no, I will not follow that. That is why we have to prepare.
Not follow that res judicata binds parties. I mean, they cannot re-agitate.
100%. That might not agitate.
Which court said that?
That portion is not. No, I will not. Lordship, that portion may again he filed a fresh writ petition. His husband, Lordship, the fresh case before the tribunal. Justice Bidisa Banerjee there, his Lordship directed to consider his case. Then 18th order passed. Again, he filed the miscellaneous application. That was also dismissed.
Where is that this finding? The proposition you are relying on?
Lordship, yesterday night, I'm not going through that. Definitely. Mhm.
You find out
Okay.
which paragraph is. Oh, you don't have. Give him a copy.
I'll give you.
He'll find out for you. Yes, Mr. Chakravarti, give you this classwork. Find out who.
Then, Lordship, again, my father or husband of the petitioner filed one application, original application before the Central Administrative Tribunal, Lordship. The
22. Para 22 of this.
Central Administrative Tribunal, Lordship, again filed. There again, his petition was directed to consider. In that consideration, we passed the order 18. We rejected his case. Again, he filed miscellaneous application. That was also dismissed. Again, he filed, Lordship, that this is the position, Lordship. Lordship, I've said, then I will.
Para 24 actually now well settled that principle of res judicata applies even to petitions arising for decision in the writ jurisdiction.
Writ jurisdiction.
Obviously, it applies. It applies before every judicial forum.
My learned friend, so the for which a feature of the service of resignation. This is the service rule, Lordship. On that day I had not brought, but CCS rules also said that if 15 years, 5 years more absences, that then he will be deemed to have resignation and he will not entitled for it. Better we file on short notes, Lordship.
Better.
Hmm.
Any reply?
Hmm.
Res judicata.
You can merit also. I'm not going to merit. I will.
And then in paragraph 22, my lord, for the principle of res judicata to be applied in the subsequent proceeding, it must be within the same parties.
Same party. Where is the different party?
Take your seat.
Must be between the same parties, and the cause of action of the subsequent proceeding must be the same as in the previous proceeding. And I humbly submit that the cause of action is different because this OA arose out of a refusal to grant me pensionary benefits on 18 January 2018. That order, 18 January 2018, which refused pensionary benefits to me, had referred to the order of deemed resignation 23rd April 2003. My learned senior friend has relied upon Justice Girish Gupta and Justice Prosenjit Mondol's judgment, my lord. Kindly comes to page 103, my lord, once of the writ petition, my lord. My lord, specifically, my lord, kindly comes to page 107.
The order from review petition.
Has my lord found it, my lord, page 107? My lord, kindly comes to paragraph upon due consideration. Upon due consideration of the grounds of review and all the materials on record, we are of the view that the decision dated 23rd April 2003 was not the subject matter of challenge in OA number 1197 of 1996. Tribunal
April
did not
23rd, 2003 edition was the present. This
is challenged in this present OA, which has come up by way of a writ petition here.
what was this order? Refusing you this pensionary this.
No, this was the deemed resignation order, 23rd April. So this was never under challenge. The court could not have expressed any opinion on this. And my lords, after considering that this was never under challenge, proceeded to record that the statement about abandonment of service must be expunged. So my lord, my learned senior friend's contention must be viewed in this context, my lord, that the order of 23rd April was never under challenge before their lordships at the relevant time. So any finding as regards deemed resignation, whether it was validly imposed, must be subject to this observation, my lord, in page 107.
But deleted only the abandonment of service was deleted, that part. But all the same, it's recorded that
All the yes, yes. And here, my lord, the cause of action which gave rise to this OA, my lord, is at page 18 January 2018 order. It is at page 115, my lord. They record that I have qualifying service of 11 years, but since I was treated to have deemed to be resigned, therefore Rule 26 applies, whereby my past service is forfeited. Hence, I will not be entitled to pension. I challenge this in the OA. And since it has relied upon the 23rd April 2003 order, I have challenged that as well in the original application. Cause of action, my lord, subject to correction is different in this case. Also, my lord, this reasoned order was issued pursuant to directions passed in OA number 547 of 2016. Kindly seize the order passed by the learned tribunal. Kindly seize paragraph 2 of the order at page 113, my lord. My lord, why did the tribunal proceed to give a direction upon respondent authorities to consider my pension case? The answer is in paragraph 2, my lord. It is noticed that MA number 145 of 2016 that the applicant has himself averred that in the month of March 2015 he has received a communication from the head office ICAR such and such to the effect that his case of pensionary benefits is under consideration and the decision of the competent authority will be intimated in due course. It is on this anvil that the OA was disposed of with the direction upon the authorities to give a final decision with respect to my pensionary benefits.
So that question is still open.
Yes.
No, but direction to consider that does not mean automatically that you have a right to get pensionary
No,
benefit.
no.
Independently also, you will not can argue that there was a res judicata, which you have answered also. So therefore, two things. One is that this is a different cause of action, pensionary benefits. Since it was dependent on the previous one, therefore you have challenged. Secondly, that it was not barred by res judicata because review order division bench said that that is not under challenge.
Yes.
Where is that order? 23rd of April 2003, the
Page 75.
75. Yes.
If I may be allowed to place one last judgment, my lord.
Judgment.
Another proposition in that judgment is since I had shown, my lord, pages 185, 186, where they had apparently intended to initiate a disciplinary proceeding but did not. And with Krishnakant Parmar's case, my lord, the Supreme Court has said that unauthorized absence, you have to give an opportunity to the employee. That is the proposition. My lord. DK Yadav's case I've already cited on last occasion.
Mr. Kumar, we will permit him to cite the judgment, but you are entitled to answer also. Right now, he will be citing. Yes. But this has direct bearing on the issue.
My lord, let me read the relevant paragraph. I'll hand over the copy to my learned friend. It kindly comes to paragraph 16, my lord.
We are there. Read.
In the case of the appellant referring to unauthorized absence, disciplinary authority alleged that he failed to maintain devotion of duty in his behavior was unbecoming of a government servant. Question whether unauthorized absence amounts to failure of devotion of duty or behavior unbecoming of a government servant cannot be decided without deciding the question whether absence is willful or because of compelling circumstances. If the absence is the result of compelling circumstances under which it was not possible to report or perform duty, such absence cannot be held to be willful. Absence from duty without any application or prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventualities due to which an employee may abstain from duty, including compelling circumstances beyond his control. But in such case, the employee cannot be held guilty of failure of devotion of duty or behavior unbecoming of a government servant. So these are the relevant. And the crux of the issue that I'm trying to raise here is that an opportunity ought to have been given. That is all.
Yes, Mr. Kumar, what is your answer, please? Disciplinary.
One judgment of Supreme Court where the person concerned was unauthorized, resigned, again withdraw. Then the matter went to Supreme Court. Supreme Court said that no, as you resign, you are not entitled for pension. You are entitled for the gratuity and whatever it may be, not the pension. Pension benefit you have lost.
You have other judgments also up your sleeve? These are
Number of judgments.
no, don't cite one each time. Give a copy to him so that he can answer this also. And this is the last one we are hearing from you. Both of these.
Here, my lord, he had resigned and the resignation was accepted.
Withdraw.
Here, the
Said
factually it
no,
is
no,
different.
in the
Paragraph. Which paragraph?
Paragraph 3,
Last
my lord,
paragraph
kindly see.
is on the-
Kindly see paragraph 3.
I said so.
Video or office
It
or
also took out last night.
No, no,
Before. Then give us the paragraph.
Or yesterday morning I have come from outside. Due to some-
Thank you for having taking the trouble of coming and arguing.
No,
But cite the paragraph all the same.
Lots of next day I everything.
No, they will know next day. You cite a paragraph.
Lord, last portion of the order is said Supreme
Paragraph of this judgment which you have
Court,
cited.
Supreme Court said that you are not entitled for the lordship
Where? Show us that paragraph.
for the region mentioned above the present
Which paragraph?
12 para 12 lordship. Same clause lordship, everything same lordship. Because he resigned, withdraw, BTC court, no withdrawal. You deemed to have resigned, you will not get pension.
Paragraph 12.
Conclusion.
But the reasons mentioned above the present appeal is partly allowed.
Okay.
What is the reasoning?
For future lordship, the 26 lordship, same. Next, para 14 lordship.
Paragraph 14.
Lordship, we have one lordship.
page
That
11.
ends-
Kindly
Page
lordship, page 11.
Page 11 lordship.
14 is a quotation from another.
Same thing lordship. The CCS. One person absented for 23 years, 25 years, and say that when I advise go join, one day he join, he is entitled, but he is not joining. Problem is this. I fighted for this. I say that go and join for 1 day, 5 days, but he is not ready.
But here it's an outright resignation, not the,
Resignation, then withdraw. Withdraw, then said.
this was outright resignation, not deemed registration. Your case is based on whether we should deem it as resignation or not.
Here we treat as deemed resignation.
This case, it was the rule cited was regarding direct resignation, actual resignation,
We
not
accept
deemed.
resignation, withdraw, but authority not allowed to authorize withdraw the resignation. Said that no, you are resigned same.
Your closing arguments. When can both of you file your written notes?
Not
When can you file written notes? Short, very short written notes. Just these points. You have not paid out too many points. When? When?
1 week, let's say next Tuesday.
Next Tuesday.
Great.
Thank you. Oral arguments are concluded. Full stop. In order to enable learned counsel for the parties to file their respective written notes of arguments, the matter will be listed next on September 1, 2026 under the heading to be mentioned.
Look at great fraud.
Thank you very much. Yes.
2-3 more judgment, but I will not cite.
But don't erroneously put those extra judgments in your written notes.
No.
No, by mistake.
No.
Again, you'll do it in midnight and you'll incorporate all those while feeling sleepy and all. You ensure that extra judgments are not by
I
mistake.
have some problem, personal problem. That is why.
What? Sorry.
No, not problem. Lordship, I have to manage number of things because this is not for saying. I suffer from cancer 4 stage. I have to manage property different places because something. Get what?
You are very brave, Mr. Kumar. This is
15
serious.
days I was in the Tata hospital.
You're
Uh,
very brave,
Not a great person.
and people should learn from you these things.
Great person.
Thank you. Yes.
My lord.
Yes.
My lord, I am for the appellant. My lord,
Appellant
I am
respondent.
in my rejoinder, my lord.
Very short.
My lord, I will try to be as brief as possible, my lord. Only rejoinder, my lord.
There has to be only trial, no error.
Yes.
You have to try and be successful in that.
Yes.
Yes.
My lord, the judgment, my lord, which my learned senior friend has, my lord, relied upon
Yes.
in Rekit and Coleman versus Jyoti Laboratories.
Right.
If my lord kindly takes that judgment once, my lord.
Yes. Okay, Coleman.
My lord, firstly, if my lord kindly takes the first paragraph. The appellant manufactures ultramarine indigo nil, both in liquid and powder form, under the trade name of Robin Blue. The product is used for whitening fabric. The respondent number 1 also sells a whitening agent, which is an Insta Violet concentrate under the trade name Ujala. So, my lord, here, my lord, the judgment is between two competitors. It's in a proceeding between two competitors. Now, my lord, here in this judgment, my lord, the Bonnard and Fraser, both the judgments are not considered. My lord, the judgment.
Bestable
Yes.
followed Bonnard and incorporated Bonnard test. Bestable was considered here.
Yes, that is correct, my lord. But my lord, in this judgment per se, the Bonnard principle has not. The Bonnard and Fraser, both the judgments were not considered. My lord, what was considered is Justice G.K. Mitter's judgment in National Sugar. My lord, that is at para
22 considers bestable.
yes. Para 22 considers bestable. Para 23 considers Justice
mills.
G.K. Mitter's judgment.
And then after considering both, para 24 it is recorded, it is not unreasonable to assume that English law, even if it is stated in Bestable's case, might not be applicable in this country.
Yes.
For the learned judge to single judge to consider and determine this.
Now, my lord.
But
here,
yes, you have a point because it ends with para 24 ends with, but it can at least be said that the appellant has an arguable case. So it is held that might not be applicable in this country for the learned single judge to determine this, at least arguable. So it was, you may say that this was not conclusively decided in this
judgment. My lord, and my lord, one more aspect is, my lord, I have, my lord, relied on, my lord, the last judgment of the Honorable Supreme Court in this matter. That is the Bloomberg Z, my lord, judgment. It's a very recent judgment of the, my lord, 3-judge bench of the Honorable Supreme Court, my lord, which considers the Bonnard principle and, my lord, upholds it. And there also, my lord, the issue was, my lord, the appeal, my lord, the SLP was from an ex parte ad interim order, which was upheld by the Honorable High Court. Thereafter, my lord, the Honorable Supreme Court has set it aside. My lord, now, my lord, if I may take the next judgment, which is National Sugar.
Yes.
My lord, National Sugar, my lord, if my lord kindly sees, this is, my lord, in an action for defamation, my lord, between a publishing house and, my lord, the National Sugar Mills Limited, which was a government company. My lord, kindly considers paragraph 1, my lord, the portion which has been set out at the bottom. My lord, this is the the infringed action, my lord, which was under challenge. This was the publication that was made before the, my lord, newspaper. My lord, here, my lord, the intention to my lord, malign and to my lord, it was done with a malice. That will be evident. In our case, my lord, with the, my lord, I have already submitted on facts. My lord, I will just, my lord, summarize that there was no intention to, my lord, malign at all in our case. and there was absence of malice in our case. My lord, and now, my lord, here is an action of an injunction petition being decided in an original side proceeding before the Honorable High Court. In this matter, kindly takes paragraph 13.
1-3.
1-3 of this judgment.
Yes.
3 affidavits in opposition have been filed herein. First by defendant Ashutosh Mukherjee himself, and thereafter, my lord, 2 other defendants, they have filed their opposition. So, my lord, the decision which was taken, that was not an ex parte decision. My lord, it was decided on merits of the injunction petition itself. Now, my lord, I will show now, my lord, paragraph 13, my lord, side by side, if my lord kindly also sees the Bloomberg judgment, paragraph 13. My lord, in paragraph 13, my lord, the ordering portion is, since the proceedings are now listed before the trial judge on such and such date, we direct that it would be open to the respondents to renew their application for injunction. My lord, I'm sorry, my lord, it's at paragraph 13, page
Yes.
10.
Yes.
My lord, if I may place, since the proceedings are now listed before the trial judge on 26 March 2024, we direct that it would be open to the respondents to renew their application for injunction, on which the trial judge shall pass fresh orders after hearing the parties and bearing in mind the observations which are contained in the above segment of the judgment and order. So, my lord, here the ex parte order was set aside. And, my lord, there was a direction for consideration of the injunction. My lord, I am also making the same prayer. Same prayer. My lord, I am not asking for now, right now, I am not asking for that no pre-trial injunction should be given. In fact, that is the law, my lord, as per Bonnard, and which has been settled up till Supreme Court. My lord, my lord, want a hearing, my lord, on merits of the injunction petition and setting aside of the ex parte order. Because, my lord, today, my lord, I am armed with, my lord, 2 test reports, scientifically backed, and, my lord, this is the defense of truth. The presumption of truth, my lord, is in my favor. My lord, now, my lord, again, my lord, I apologize, my lord, I'm taking my lord to and fro. My lord, if my lord kindly sees, my lord, the national sugar judgment once again.
Yes. We have 2 on our right hand and throw on our left hand. So no debate.
My lord, here the issue was
Yes.
that, my lord, sugar, the sale of sugar, there was a difference, my lord, and it was, my lord, imputed that the difference was something which has been cheated, and the property was overvalued. Difference in sugar price. It was 52 rupee versus 47 rupee. That was the, my lord,
Yes.
aspect. Now, my lord, here kindly sees paragraph 14. My lord, before granting an order of injunction, the Honorable Court has gone into all these aspects and has, in fact, my lord, taken a decision on prima facie on the basis of the affidavits filed by the 3 defendants. My lord, paragraph 14, it is significant to note that the deponent did not himself contact, here the deponent is the defendant number 1, Ashutosh Mukherjee, did not himself contact any of the persons who had purchased sugar from mill directly, but his charge was based on 2 receipts which had been made over to him by Suganchand Anchila. The paragraph above quoted does not show who it was who had represented to the deponent that while payments were being received at rupee 52 per mount, receipts for rupees 45 only per mount were being granted. Now, my lord, kindly sees paragraph 19. In order to put matters beyond any doubt, I called for the production of the accounts books of the plaintiff company and the books which contained carbon copies of the receipts made out for sale of sugar. The two counterfoil books produced show that two receipts were made out in favor of Sampath Raj Jain on such and such at the rate of 45 per mount and the other at the rate of 5 per mount. So, my lord, there was an independent inquiry also. Now, my lord, paragraph 22 and my lord, lastly 23, which also my lord, my learned senior friend has relied upon. Prima facie, therefore, it appears the plea of justification which the learned counsel for the defendant wanted to rely on is without any foundation. If, in spite of the plaintiff company producing its books of accounts and the copies of the bills, the defendant had produced an affidavit from someone who had actually brought sugar from the mill and stated that he had paid at the rate of 50 rupees and obtained a bill showing payment at the rate of 45 rupees. Only then one might possibly take the view that there was some basis for the defendant's plea of justification. Now, my lord, paragraph 23, my lord, this is the, my lord, seventh line, my lord, from top. In support of this, Mr. Mukherjee, my lord, Mr. Mukherjee was appearing for the defendants, relied on Bonnard versus Perryman. In this case, North J had granted an interim injunction on an interlocutory application. This was, however, upset on appeal by the division bench where Lord Coleridge, with whom Lord Esher, MR, and Linley, Bowen, and Lopes LJJ concurred and held that although the court had jurisdiction to grant such relief on an interlocutory application, it would be very slow to exercise such jurisdiction. It is necessary to refer in brief to the facts of this case. Then, my lord, it goes into my lord Bonnard and Perryman, my lord, in detail. My lord, I will not trouble. My lord, paragraph 27 is already, my lord, referred to in the other, my lord, in Rekit judgment. My lord, so, my lord, my respectful submission is, here, my lord, there was, my lord, the defendant, he could not show, he could not justify the statements that he has made. In our case, my lord, there is a, my lord, we have two, my lord, test reports in support. Now, my lord, since, my lord, the other question is with regard to the veracity of the reports. Now, my lord, this is with the greatest of respect to my learned senior friend. My lord, the veracity of reports can be the subject matter of the trial. My lord, that is something which the Honorable Delhi High Court also says. My lord, if I may, my lord, take my lord, through some of the, my lord, passages from the Delhi High Court judgment in Stand Nutrition. My lord, in fact, in that judgment also, my lord, the test reports were challenged. My lord, kindly takes the Stand Nutrition judgment, my lord.
Yes.
My lord, kindly takes paragraph 70 at page 26 of the report.
Yes.
My lord, if I may place, defense of truth justification. The defendant number 1 has taken the defense of truth on the basis of 2 reports obtained by him from 2 independent laboratories. Both the laboratory reports confirm the fact that the claim made by the plaintiff with regard to protein content in the plaintiff's product is untrue. After the impugned video was uploaded, in order to ensure that he has reported correctly, defendant number 1 once again ordered 2 units of the plaintiff's product from the plaintiff's website, and 1 unit in a sealed condition was sent to Eurofins, which is a NABAL accredited, is also recognized by FSI. The test report issued by Eurofins also revealed such and such. Now, my lord, kindly sees paragraph 72. To be noted, the plaintiff has nowhere questioned the veracity of the findings of the laboratory reports relied upon by the defendant number 1, nor has it submitted any laboratory report or other scientific material of its own to rebut the findings of the laboratory reports relied upon by the defendant number 1. Plaintiff has only questioned the credibility of the laboratories issuing the aforesaid reports on the ground that they are not recognized by FSI, and therefore their reports cannot be relied upon. Now, my lord, on this, kindly sees the finding at paragraph 73.
73rd last line.
Third, yes, I am very grateful. My lord, that is what I am relying on. The veracity of the results of the laboratory reports can only be tested at the stage of trial. At an interim stage, the court is only required to take a prima facie view if the defendant number 1 has been able to establish his defense of truth of the assertions made by him with written. Now, my lord, it's not my case, with the greatest of respect to my learned senior, it's not my case that, my lord, the samples were tested as per FSI guidelines or as per the, my lord, the regulations, which is named Food Safety and Standards, Contaminants, Toxins and Residue Regulations. It is not my case. My lord, if on this, my lord, may I invite my lord's attention to page 139 of the supplementary affidavit.
Ms. Chakraborty, is it your contention that a product may be a food product, touted as a food product, at the same time it may be a formulation also? Because you have relied on the formulation yardsticks.
My lord,
As a specific point is taken by them that no, that was not applicable because it's a it's a medicine, sorry.
yes, Ayurvedic.
So you say it may be a medicine, at the same time it may be a formulation.
My lord, on this, my lord, if I may show their own representation. My lord, this is, my lord, on the Amazon website.
No.
My lord, I will just, this is their representation. This is their representation.
Nothing which is not before the trial.
Very well. My lord, in this, my lord, they have represented it's a formulation, and the category, product specification, they have said herbal nutrients.
We are prejudiced, but we'll forget the prejudice when we go out of court. Because it was not a part of the record we wanted. We just put it to you that it's your contention that it may be a formulation even if it's labeled as a medicine. And it may be a medicine as well as a formulation.
My lord, this is their representation, in fact, that formulations and supplements.
Which we don't see.
Herbal, my lord, herbal
Yes.
supplements. Now, my lord, kindly sees his case, page 139 of the supplementary affidavit.
We'll be coming back to these judgments.
My lord, on the judgment aspect, my lord, I have.
More or less, yes. Yes, 130.
My lord, this is their notice.
Half a minute.
My lord.
Sorry.
My lord,
Yes.
my lord, this is their notice dated 17 July 2025.
Right.
My lord, this has been issued by them after the video has been uploaded. My lord, they could have challenged the video. They have not done it. My lord, because, my lord, in the website, my lord, there is already in our website, there is, my lord, already a dedicated, my lord, portal for challenging the tests. We have shown that, my lord. Can you challenge justified? They have not done.
You are not an authority who will decide on its own.
That is true. But, my lord, I am open.
That can at best operate as a notice to you.
My lord.
That, see, I am challenging. But that is not mandatory. I mean,
That
don't
is
find it mandatory. You are not the adjudicator.
absolutely, absolutely. But, my lord,
Might not have done it directly, come to court, no difficulty there.
absolutely, no difficulty. But, my lord, the only reason I am showing that is because, my lord, there is absence of malice from my end.
All
My lord, I am open to, because that is the reason, my lord, my lord, in reply also I have said that we are asking you to contest the report so that we can also incorporate your feedback in the video. My lord, in that respect, my lord, now kindly sees 139, paragraph 3. This is their notice. You have done some testing of the aforesaid medicine of my client for ascertaining heavy metal content in them and compared the results with limits as set for unspecified food products by FSI. So this is their case. FSI is their case. And my lord, now,
Not their case. They're saying you have compared with some unspecified food products.
yes, this is their aspersion,
Yes.
to which my lord kindly sees my response, which starts at page 141. My lord, at page 146, paragraph 12.
Yes.
However, the test reports
Yes.
is issued by Eurofins Analytical Services India Private Limited after level 2 testing revealed an even more alarming situation regarding your client's product. The analysis detected 16.98 mg per kg of lead and 7.28 mg per kg of mercury in the product. These levels are far exceed the permissible limits prescribed by the Ayurvedic Pharmacopoeia of India. My lord, this is what I am relying upon. I am not saying FSI limits. That is not my case. Which set the maximum allowable limit for lead at 10 mg per kg, which is 10 ppm, and for mercury at 1 mg per kg in Ayurvedic products. Now, my lord, I have shown the full volume of the API.
It's not a question of whether you relied on FSI or not. FSI is purely food. But in the API also you relied on those, the formulation chapter, not the medicine.
Yes, because my lord, this volume 2, part 2, this is what is applicable in formulations. My lord, volume 1, part 1 is for single drugs. And volume 2, part 2 is for formulations, which my learned friend's product is. And that is why, my lord, I have relied on API limits, permissible limits under API. Well, in fact, my learned senior friend has also shown that their drug license at page 128, my lord, it says that API, my lord, part 1 for volume 1, that's they are relying upon. They are saying that the limits are as per API part 1 volume 1. So, my lord, they also, my lord, and my lord, I have shown, my lord, the legal notice in, my lord, part 2 volume 2, which says that under Drugs and Cosmetics Act, API is recognized. API volumes is, so my lord, Drugs and Cosmetics Act, API comes in. The definition of 3H, API comes in. So API is applicable.
API is applicable, no doubt on that. They say a different part of API is applicable regarding drugs. Your apple and oranges, Mr. Ghosh,
My lord.
Mr. Bachot is also.
My lord.
He came in.
My respectful submission is it's not apple and oranges because I am not relying on FSI, which they are trying to, my lord, portray. I am relying on only FSI. I am sorry, my lord,
The other way around.
the other way. API. And API, my lord, permissible limit only I have, my lord, shown to my lord.
So what happens if a product complies with part 1 but
My
does not comply with part 2? Then you have to prima facie show that this may come under either category.
My lord, since it's a formulation, my respectful submission is part 2 is applicable. Volume 2, part 2 is applicable because it is formulation.
API, let us see whether part 1, as you were saying, is applicable only to single drugs.
Yes, my lord, that document, my lord, will not have because it's not
achha,
part of, but I have it, my lord, in soft copy. I can, my lord, show it from my tab. My lord, this is API. My lord, define. There are 5 volumes in part 1. All deals with single. All deal with single drugs. If I may show.
Volume 1. Din. Good. Yes.
Now, my lord, with regard to, my lord, the use of the, my lord, word agriculture and, my lord, there was a and residue. My lord, a confused, my lord, if I may explain, my lord, there are two reports.
Hmm.
The first report says supplements. Kindly see page 42. My lord remembers. First report says supplements in the group. That has gone for retesting. Because, my lord, we wanted to be doubly sure.
Chakravarti, their premise was that it's not a food supplement. Their product is not a food supplement. Supplement relates to food supplement.
I'm also saying so.
So you are saying it's a food supplement.
No, my lord. I'm not saying.
It's not a food supplement.
I'm saying, my lord, I am taking
Just
their
treat it
case.
as a food supplement.
My lord, I'm treating it as a supplement. Supplement Ayurvedic medicine, the way they are, my lord,
These are
portrayed.
different things. These are
Right.
different paradigms. Supplement, then every medicine is a supplement. Food supplement is something else. Suppose protein powder
My lord.
or something like that. Even nowadays, multivitamins they fall under both categories. Some take them as supplements just to bolster their health, and some take them as medicine, depending on if there is any condition.
My lord.
So there are certain things which may be food supplements as well as drugs. This is a ashwagandha, all right.
Fine.
They say it's a medicine. Their product is a full-fledged outright medicine. It's intended to be used as an Ayurvedic medicine.
Fine.
So therefore, you tested it as a food supplement, which is not correct, and agricultural product not correct.
My lord. My lord, with regard to that, my lord, if my lord kindly sees page 42 of my stay petition.
Hmm.
My lord, here, my lord, the group mentioned is nutritional supplements. Nutritional supplements. My lord, this is the first report. Now, my lord, the retesting report is at page 46.
Hmm.
My lord, page 46. My lord, it's the second report for the retesting.
Hmm.
This, my lord, the same batch, same sample, everything was same. But my lord, I don't know how, my lord, the group name has been, my lord, probably because it's a heavy metal. That's why the group name was mentioned as residues and contaminants in food and agricultural products. My lord, be that as it may, my respectful submission is, I'm not shying away from, my lord, arguing on merits also. My lord, my respectful submission is that, my lord, the first report itself is scientific, my lord, evidence that my statement which I have made, and that was also, my lord, qualified by a disclaimer. I have asked the viewers to also do their independent research and testing. So, my lord, that is not defamatory per se.
You say it's poison with 2 question marks.
Two question. Yes, question mark is there. That is because, my lord,
You ask me, are you a judge with 2 question marks, and what happens?
my lord, that I will not ask.
That aspersion comes.
My lord, whether the
Aspersion is there. Poison. And 2 question marks.
My lord, if my lord,
2 question marks enhance the effect.
my lord, the thing is, my lord, lead, mercury, every day, twice a day. Twice a day.
Hmm.
Consuming it, my lord, and my lord, my learned senior friend, with the greatest of respect, my lord, are we waiting for people to die to test, my lord, a product? My lord, if my lord now kindly sees, so my lord, one report is already there which correctly mentions it as, my lord, supplements, nutritional supplements.
Correctly according to you. This it's not correct. It's not a nutritional supplement. It's a medicine, full-fledged Ayurvedic medicine.
Supplement is what they have stated in their, my lord, Amazon website. They have also mentioned
Which you
formulation.
can't see.
Well, it's in public domain, that's why, my lord. Because
So we also won't go home and see. We are curious, but we won't. Deliberately, we won't now.
very well, my lord. So, my lord,
Very well. So you say it whatever it is captioned as
my lord,
medicine or whatever, this is also a nutritional supplement, basically.
my lord, my lord. And my lord, the second question, my lord, this is the first aspect. Second aspect is, so there are, my lord, 4 test reports. My lord, 4 test reports which
2 test
have,
reports from by different labs, they are retests.
yes. My lord, all these reports say that lead and mercury are in alarming high rate. 4 test reports, my lord. Now, my lord, whatever may be the yardsticks, I have tested it to check the contents of the heavy metals, and the heavy metals are found to be in excess quantity.
Yes.
Now, and my lord, third thing, my lord, I have applied the test reports, only the quantity. My lord, FASI, etc., I have not applied. I have applied API permissible limits, this far exceed. This is the third aspect. Now, my lord, the fourth aspect is that, my lord, in all the test reports, my lord, whatever may be the yardstick, my lord, the thing is, they have not disputed. Emami has not disputed that, yes, there is excess amount of lead and mercury in their product.
Disputed, not disputed. They have disputed in the suit.
Excess limit, they are not disputing. They have said that, sorry, we have bhashmas, Shwarna Bhasma, Yashad Bhasma, and Shilajit mineral. That will diffuse the effect of these heavy metals in
That's
excess
not exactly
quantity.
what they said, Ms. Chakraborty. They had said something like that these are required to purify the product or the there. That's why there's some residue of
My-
lead and mercury.
My lord.
But that, yes, in a sense, you are right. In a sense, you are right.
My lord, in fact, their injunction case is this only. Their plaint case is this only. That is the reason they rely on the 3 expert report.
Yes,
The 3 expert report.
Ayurvedic experts.
Yes, and those reports were, my lord, taken after the video was published.
Maybe.
Yes, my lord, sum and substance of those reports are, yes, it is in excess quantity, but we have the bhashmas and the minerals to tackle the effect of excess heavy metals. Now, my
Show
lord,
us one of those reports. Show us one of
My
those
lord.
reports. Anyone
yes,
where it is said that those will neutralize a sort of
my lord,
diffuse.
my lord. My lord, kindly sees, it is in fact set out in their pleadings.
Anywhere. Show us from anywhere. We'll
Very
just
well.
look into it.
Page 76, paragraph 22 of the petition. My lord, may I please?
Come to next page.
My lord.
That italics.
Since Jhandu Ashwagandha Gold Plus capsule contains 2 metallic mineral bhashmas, namely Shwarna Bhashma, Yashad Bhashma, and 1 mineral ingredient, namely Shilajit, in my opinion, the testing and limits of heavy metals do not apply to this formulation. Now, my lord, also very interesting, the next
Paragraph. Yes.
Yes, my lord. Herbal mineral and herbal metal formulation. Now, my lord, here also my lord, join issue, because my lord, the lead, mercury, it's inorganic. So, my lord, there cannot be herbal. This is something.
Right. Yes, whatever.
My lord, it says herbal mineral and herbal metal formulation has various metals and minerals in their formulation. So, my lord, they also say formulation. So, it is obvious that the heavy metal content in those formulation will be high. Therefore, keeping this in view, Ayush department had not mandated the heavy metal limit for herbal mineral and herbal metal formulation. The same is also substantiated by above monograph and Ayush order dated 14/10/2005. My lord, I have only relied upon API volume 2, part 2, Ayush Ministry. Then my lord, if I may read on further, the exemption from heavy metal limit testing as given bhashma would also be applicable to medicine having bhashma as ingredient, because if bhashma is exempted from heavy metal testing, then obviously the said exemption also applies to formulation containing that bhashma as an ingredient. Therefore, in my view, heavy metal limit testing is not applicable to Jhandu Ashwagandha, which is having mineral in their composition.
We don't understand this sentence. Could you explain it to us?
My
This further.
my lord. Further,
It's like the answers I wrote in the law examination when I didn't know. See, many things are said saying nothing. Please make us understand, Ms. Chakraborty, on their behalf. Further, the exemption from heavy metal limit testing as given bhasma would also be applicable to medicine having bhasma as ingredient. Because if bhasma is exempted from heavy metal testing, then obviously the said exemption also applies to formulation containing that bhasma as an ingredient. Come back to the same position. I don't understand this. This is they would be probably understanding. So what do they intend to say?
very cryptic, my lord.
No, but don't take advantage of our not understanding. You try to explain it in your own way. Because you also rely on this.
My lord. My lord, it's quite cryptic. Exemption from heavy metal test would be applicable to medicine having bhashma as ingredient, because if bhashma is exempted from it, then obviously the said exemption also applies to formulation.
Like those pictures where the stairs start from the top and then again you don't go down. I mean, it goes to the top again.
Yes.
Anyway, whatever.
So, my lord, this is
Yes, Mr. Varshi, please do.
But
Yes.
Bhashmo itself is not subject to that particular limit in 2.2, volume 2, part 2. Then a mixture containing blood of Bhashmo is also not subject to that testing.
All right.
But the Lordship see the language. Exemption given to a Bhashmo would also be applicable to medicine having Bhashmo. So Bhashmo plus something else, again that limit will not apply.
yes. My lord, and lastly, so far as my lord, the disclaimer aspect is there, my lord, in the description box as well as in the video itself, where I have, my lord, invited, my lord, the viewers to, my lord, do their independent research. And I have made, my lord, very categorically, I have made it clear that I am not funded or sponsored by any competitor or any entities whatsoever. Now, my lord, and lastly, my lord, with regard to my credibility, as my lord, to question this, because my lord, a lot has been said, my lord,
Your qualification.
my lord, regarding my qualification,
Sports nutritionist, to say.
my lord, here,
And a physical instructor with due certification from an American, some council or something.
yes, my lord, now, my lord, with my lord, I was just thinking about this matter, my lord, and my lord, the word which has come to my mind is Shottanneshi.
So then, as you understand, I mean,
My lord, now, if I may, my lord, develop this point, my lord, all Shottanneshis, my lord, be that Feluda, our own Feluda, or my lord Sherlock Holmes, or my lord Bomkesh Bokshi, all of them were private investigator. And my lord, without any police background, without any, my lord, professional qualification, my lord, they, my lord, wanted to, my lord, get into the truth. My lord, that is the object. My lord, so far as I am concerned, my lord, I don't need to be a domain expert to, my lord, comment on, my lord, something. In any event, my lord, as per the ASCII guideline, I have shown, my lord, diet, my lord, nutritionist, they are covered. So, my lord, they can comment. They can comment.
Those the expertise is
My lord.
applicable. You said something else also, that if you are a competitor or something, it's
My lord.
applicable then only.
My
What
lord.
was that?
My lord, that says that that is the ASCII code, that if I am sponsored,
Yes, sponsored.
yes, which is absent
So
in my
here you
case.
say no case of sponsorship has been made out even by them.
Yes,
Very much there.
It's there.
Yes.
that is not the case. This is a submission from the bar with the greatest of respect. I have, my lord, that is not the case in their notice, in their plaint also. It's not their case that I am set up by them, or I am their ex-employee, or I.
You have to look at the plaint and injunction and their documents annexed to.
Yes, yes, it's not the case made out.
Is there in the plaint? I don't
No,
think
my
so.
lord,
We don't recollect.
it is not there.
No direct. We can't.
The video, it's very much there in the video. It shows that. I showed it on the last
That
day.
is the, my lord,
That video.
subscription.
The video is part of my plane. What else will it?
Subscription, my lord, that is all, my lord, my lord, all.
That he sponsors. He sponsors the products which have passed the test. Something like that.
Absolutely.
My lord, every content creator
And he's
will
got
at
this
the end of the video will say that subscribe to my channel, because the tests, my lord, which I do, for
So then
that
you
I
have a
require
stake in.
content.
You may have a stake in this, but because you say, I fail, justice day passes, and then uh, you are projecting in your own video that I have failed. You not malign, but you denigrate me in a sense that you say that you call me out,
My lord,
and then at the same time you are sponsoring the persons who passed on your and on your yardsticks. So therefore, isn't that sponsoring them? Isn't there a direct interest? Because you earn money from that.
Justified.
Yes.
The website where he's selling those products.
Yes, that is there in the video.
Clearly advertisement. Very much there. I don't know why am I done.
I have not said that I am, my lord, my lord,
Sponsored by them.
promoting or sponsoring other.
You say my
I-
test is very simple. If you pass my test,
Yes,
I'll take your ads.
Yes.
Otherwise, won't.
yes. And my lord, this pass fail aspect, they also give in their Amazon, my lord. I will not, my lord, say much on this, but my lord, in the Amazon they say pass fail pass, so it's there.
So
Obviously,
that's
they have
not
to
doubt.
do everything fast. Yes. And my lord, lastly, lastly, my lord, absence of malice, complete absence
That
of
is
malice.
it, yes.
My lord, in fact, I have invited them that if you have, my lord, that is my reply to their notice, that yes, I will take down my video because I have received this notice from you, and this I will treat as a reply to my 24th March email prior to the uploading of the video. So I will take it down and incorporate your comments, and then. So, my lord, this is my respectful submission in this matter.
So we'll request both of you to file brief written note.
My learned friend is Diagut. May I just give that one clarification? My learned friend was. Acting out of that.
No, she primarily dealt with your judgments only, and she added something but
The
reiterated.
time I've come in, I've heard no mention of any judgment.
No, no, all
only
the
heard
judgments are
facts.
being
No, since the time I came in, it was only facts. On the last day, it was only facts. Doesn't matter. But I'm not coming in the way of that. I'm
Yes.
just giving that one clarification. But my learned friend's case, that letter which he showed today, my lord, they reply para 12. There's an annexure. So they rely on, my lord, volume 2, part 2,
Yes, yes.
which is not applicable. This is all I'm pointing out.
Yes,
But
you
this is all I
understand.
need
That
to.
is your
What is
argument.
applicable, my lord, is volume 1, part 1, volume 10. So therefore, my lord, these limits that she talks about doesn't apply to that part at all.
She argued that part 1 applies to single drugs.
So this is not a single track. But please come to.
It is not a single track.
please
Part
argue.
one does not apply.
But
Part two
he's
applies.
saying so. Please have a look.
But he
But
says.
please take it. No, that's the point. Not. Please come to the page she relied on. Page
46 or something.
29 ওর চিঠিটা কোন পাতায় ছিল বলো?
46, 49.
141.
Yes. No, 141.
Yes, 135.
Of the supplementary.
Oh, 141 ছিল, হ্যাঁ।
141 of the
হ্যাঁ।
supplementary.
But please come to page, but at page 146.
Yes.
At 146. This is what she showed today.
Yes. Para 12.
So, my lord, your lordship will find that for the purpose of using these weights, she is relying on annexure A2. The Ayurvedic pharmacopoeia. Now, if your lordship comes to that annexure, that starts at page 153.
Yes.
So they are relying on part 2, volume 2. This does not apply. This does not apply. What applies, my lord, I'll just show your lordship, is part 1, which is at 193. And I have given the opinions of those experts, my lord, to say that.
No limit.
But wherever it has minerals and metals, this is what applies. And to back that up, I just show your lordship my drug license. But that should take care of the problem. Drug license to the page to the but page 127. But we had given a better copy to your lordship.
Enlarged.
Your lordship will find the part number given there.
The enlarged copy, my lord, we gave. Enlarged macro Xerox. Last week I handed up.
আমাদের ওষুধটা নম্বর এই ফটোতে বোঝা যাচ্ছে না কত নম্বর এখানে বলো এটা যেটা যাচ্ছে না আরে ঠিক আছে আমাদেরটা কত নম্বরের ছোট এত ছোট দেখা যাচ্ছে
Yes.
item 4. Your lordship will find there is no reference to part 2 volume 2 in anything.
Yes, 6 and 8.
Last column. So part 2 volume 2 is not my drug license is given under part 1. Now,
And Boyo,
like I said, Lord, it is one thing, Lord, if you say all Ayurvedic products of ashwagandha are bad, poisonous, killers. He says mine is bad. Number 2, Lord, your lordship has seen the picture. Cancer, poison in a bottle. But after that, to say that this is bona fide, coming from a non-expert. And my learned friend is referring to ASCII. ASCII does not apply.
Now this is a re-argument on this.
No. She just said so.
This one.
ASCII, she just said so. ASCII does not apply because it's not an advertisement. This is a YouTube channel. This is not an advertisement. An advertisement would be if as a competitor I take out advertising saying this. So ASCII doesn't apply, Lord. So therefore that's the end of the matter, Lord.
দুটো পাতা দেখিয়েছিল রিপ্লাইতে page 90. That is also in respect of food.
And the other pages, Lord, that she relied on are to do with food that your lordship has already noted. But that's the basic difference. But they, in their advertisement, forget whatever else they are now relying on. In the advertisement, the limits that they apply, Lord, are to do with food. Very clear about that.
Reports are on
Now, in justification, they are giving a completely different reason, which also is wrong because I've showed your lordship. But that
Brief written notes when do you file?
follow, copy the
As my lord directs.
When tell us?
Tuesday.
Next Tuesday.
These matters are taken.
But make it as brief as possible, just to the point.
I only need to type this.
That is fine for us. Yes.
I only need to type.
One of them at a
But this
63 page written note by one party and probably
This is too long.
63 page by one
Make-
party,
make life
34 page
difficult.
by another party in another matter. So
Lord, make
we
life
have
difficult.
noted that
for-
in our judgment in the other matter. We'll note.
Lord, make life difficult for him. Don't permit him to have this typed out. This is too long. বললেই তো আবার লিখতে
I
হবে।
dictated my junior rights, Millard.
Oral arguments are concluded. The matter.
With my lord's permission, may I make a humble submission, my lords? I mean, this matter for Google LLC, that's for YouTube. May I make a small submission, my lords? Just a small submission, my lords, that the list is between the contesting parties and the respondent herein. I need not be a party to this appeal, and I may be deleted. That's my small humble submission, my lords.
No,
I
you
may
are a
be
party. You are still a party in the suit. Yes.
Yes.
We cannot
party
expunge
to
your name
suit.
here. You may take a neutral stand, but we
Oh,
cannot expunge you from here because you are a party to the suit. You are necessary here.
obliged.
This is the best brief to hold.
Yes, Google. Yes. Oral arguments are concluded, Bolam, Mr. Learned counsel for the parties are requested to file the respective written notes of arguments on September 1, 2026, when the matter shall be listed for such purpose under the heading to be mentioned. We'll take up the next matter when you come. Yes, Mr. Hon'ble.
Item number 3. Airports Authority of India, interested parties.
Have you filed any addition of party application? Are you a party?
My lord, may I just, otherwise you also will not. The originally appeal was filed, my lord, against an order passed by the district judge in a reference petitions under section 18 of the 1994 Act, 1894 Act. My lord, during the pendency of that appeal, now the 1894 Act has been repealed by the new Act. Then Pune Municipal Corporations came. And in fact, no amount was deposited or paid by the my lord, acquiring authority to the my lord, appellant. It was heard by the Honorable Justice, my lord, the division bench presided by Honorable Justice Soumitra Pal as Lord. The lordships held that in view of the decisions of the Pune Municipal Corporation followed in another matter, so the petitioners shall be entitled for the compensation under the new act if the lands are not returned. There's the directions given for return of the land, and if it is not there, then the compensation is to be computed as per the new act.
Land has been handed over to them.
Yes, because it was acquired for the purpose of
Their
purpose. Now they preferred an SLP. In fact, they didn't prefer an SLP against the division bench judgment straight away.
Yes.
When the division bench judgment was not complied with, we filed a writ petitions that either you return the land or pay the compensation. After the order of the learned single judge, they preferred two SLPs, different SLPs, one against the division bench order and another against the order of the learned single judge. Now, in that SLP, the Supreme Court, this order was also passed by the Honorable Justice Arun Mishra, as his lordship then was. Followed his February 2018, the first 3 judges bench judgment. The first one, not the 5 judges. He said that since Pune Municipal Corporation is par inquirium, so this comes within the purview. So he remanded the matter back for hearing of the now the scope of the appeal limited to the section 18 reference order.
They were not. They did not appear in the section.
No, they didn't appear. In fact, you also is well aware of section 50 of the 1894 Act, where it is for the local authority or company. They are the beneficiary of the acquisition. Kindly take section 50. This was interpreted by the Honorable Supreme Court in subsequent judgments. One is most probably UP Development Authority. They could have approached section 50 has also got it. That was the only limited scope available if the land was acquired.
Oh, for the purpose of determining the amount of compensation, they may adduce evidence. They did not appear there or
there before the reference court, they didn't appear. Even before the appellate court.
The Airport Authority of India.
Airport Authority of India.
Yes, what do you say to this? Actually, section 50, your scope is limited. You can file an application before the collector or the court, or you may implead yourself there for the purpose of may appear and adduce evidence. Not that you get to you need to be impleaded also. In any proceeding held before a collector or court in such cases, the local authority or company concerned may appear and adduce evidence for the purpose of determining the amount of compensation. That is your limit, because you are ultimately claiming to the state.
Yes.
State has acquired their grievances against the state.
My lord.
Although you may be affected, but you could only adduce evidence there. You did not appear. You chose not to appear there.
I don't know, in so far as the merit is concerned, what they can say at all.
You don't have much right, because your right is limited to section 50 subsection 2. You may appear and adduce evidence for the purpose of determining the amount of compensation, which you have not done.
My
so
lord,
that is a question of
only your lordship's kind attention I am drawing
to
the last order of your lordships.
Yes.
That was a wrong recording of fact.
Yes, yes.
That is
only
a
that
wrong
thing
recording.
that can be corrected. My lord,
said
they claim
2013 Act.
Compensation will be determined under
no.
2013 Act. But
no.
This is not the case under 2013.
Supreme Court judgment. Have you got that order?
Yes.
Cite that order, please.
My lord, it is there in the.
Can it also just to look at it?
It is
annexed in an application filed by me for
That the appeal to exemption by just.
decide the appeal as to the quantum of compensation under the LA Act 1894. The last
It
paragraph.
was the other way around. Provisions of 2013 are not applicable.
Not applicable.
So we'll record that in our August 11th order. We erroneously
wrong
recorded that.
recording.
Yes, my
That,
lord.
that will save you.
Yes, my lord. Only my submission to that extent only.
We'll record it. Let us pass order on this. We'll rectify our previous order so that when the appeal is taken up for hearing, Learned Counsel having instruction to appear for the Airport Authority of India Limited, comma, the body for which the subject plots were acquired, comma, submits that in the order dated August 11, 2026, it was erroneously recorded that the Honorable Supreme Court remanded the matter back for computation of compensation under the Fair Compensation and Transparency in Land Acquisition, comma, Rehabilitation and Resettlement Act, comma, 2013. Whereas from the order of the Honorable Supreme Court dated February 20, 2018, it will be evident that the Honorable Supreme Court observed that the provisions of the 2013 Act would not be applicable and that the matter was remitted back to this court to decide the appeal as to the quantum of compensation under the Land Acquisition Act 1894. Full stop. Next para. Learned Counsel for the appellant agrees with such proposition. Full stop. Accordingly, comma, let the order dated August 11, 2026 be deemed to stand corrected to the limited extent that whereas we had recorded that the Honorable Supreme Court had remanded the matter for computation of compensation under the 2013 Act, comma, the name of the said act should be read as the Land Acquisition Act, comma, 1894, close, instead of the 2013 Act. Full stop. Let this order be deemed to stand incorporated in the order dated August 11, 2026.
May I now proceed with the merit?
Yes. এবার মেডিটেশনে এবার যা হবে ইয়ে তো শুভ্র তুমি যদি তুমি চলে যাও মাঝখানে তাহলে এই পোর্শনটা আগে হবে তারপর যেটা পরে ইয়েস
Just give the 2-3 dates, my lord, because dates are not very relevant.
Right.
My lord, the acquisition proceedings, my lord, started 7th of May. A 4-1 notice was issued on 7th of May 1999. It was gazetted on 20th May 1999. এক second, দাদা।
Yes.
But it proposes, my lord, the acquisitions of, my lord, the land, my lord, which is the tea garden land. My lord, that has a special distinction, my lord.
Yes.
9.14 acres, 142. 9.41 acres of land was sought to be acquired, my lord, for Bagdogra Airport, your lordship. The proceedings in 1999, my lord, the collector, my lord, made the my lord, computations, my lord, for only for tea bushes and just my lord, assess the compensation to be payable as rupees 2,85,545 only. Lord, it was in fact, it was the 12-2 notice was issued. Then, my lord, when it was served, my lord, we raised the objection, section 18 reference. Now, the reference, before the reference court, my lord, in fact, before the collector, we paid for the market value of the land also, as well as the compensations, my lord, for tea bushes, loss of profit. My lord, these are under the head as available under section 23 of the Land Acquisition Act. Now, in this appeal model or limited, the claim for market value of the land was denied by the district judge. But on the ground that as on the date when this acquisition is made, there was no lease deed subsisting. But kindly take the order of the district judge, page 39 in volume 1, part 2, part 1. Sorry, part 1. You'll also get the facts also, my lord.
Yes.
Okay, you can skip this, my lord, page 39. It starts.
This is the impugned judgment.
This is the impugned judgment.
Yes.
My lord, the issues kindly take 41.
Yes.
These are the issues framed. There was a issue of limitation that was taken by the state that the petitioner didn't approach for section 18 reference within the time specified. That was decided in favor of the petitioner. Now, straightway come to Malad, page 43, issues number 4, 5, and 6. These issues are taken up together for the sake of convenience, as these are interlinking. It has already been stated in page 3 of the judgment that the petitioner's claimant has claimed thereunder that the land acquisition Calcutta Darjeeling at the time of making the award failed to look into the actual number of tea bushes on the accord, the productive life of the tea plants, then market price of the tea was also not, the damages suffered, and the consequential loss by severance of the tea garden was overlooked. Total yield per year of the garden was not appreciated. Then market value of the land at the relevant time was not taken into account consideration. The reductions of the productions. The learned government pleader during his argument submitted that the compensation awarded to the petitioner's claimant was made on the basis of a government order and that was legal and just and proper. By mentioning such government order, learned government pleader probably referred to Exhibit E, which is a communication made by the Deputy Secretary to the Government of West Bengal, Land and Land Reforms Department, Jalpaiguri, which was sent to the collectors of several, including Darjeeling. I am saying so because save and accept the said communication such and such, no other document containing any government order in this respect was produced by the state during the trial. Now let us have a look in the matter on the basis of the evidence on record and legal principles. The matter to be considered in determining compensation have been stated in section 23 of the LA Act as per clause 2nd of subsection 1 of section 23, the damage sustained by the person interested by reason of taking into the standing crops or trees which may be on the land at the time of collectors taking possession thereof must be taken into account in determining the amount of compensation to be awarded for land acquired. And there has already been mentioned herein before that the LA collector awarded the compensation after finding that there are about 12,300 tea bushes. Tea bushes of the acquired land that also appearing from paragraph 6 of the examination chief of OPW1 to substantiate the above claim of the state regarding the number of bushes. It examined OPW1, a surveyor of the land acquisition department Darjeeling. It appears from the evidence of the said witness that he has no personal knowledge about the survey of the land in question. It is also seen from his evidence that there was no report before the LA collector regarding the counting of tea bushes. It should be tea bushes. It is otherwise, it is now here appearing in his evidence that the said counting of tea bushes of the acquired land was made in presence of the petitioner or Anybody after serving notice to the company. Whereas in paragraph 9 of the instant petition, the petitioner claimed that there were in all 20,763 number of tea bushes on 6.18 acres out of 9.41 acres of the acquired land. PW1 of
was
this
decided in your favor, at least regarding the number of.
this number of tea bushes, it was decided in my favor. Now let us take
Later, rate of rupees 17 is not disputed.
no.
Very well.
Kindly state then skip this portion of page 46. My lord, after 7 lines from exhibit 8, has got it.
Yes.
From exhibit 8, it is seen that the land was given to the petitioner claimant by the state for commercial stroke industrial purpose through cultivations and productions of the tea. In other words, the prime purpose of the commercial industry and the question of compensation towards the land should have considered from this point of view. The OPW1 in his examination in chief, Satyendra has clearly stated in paragraph 8 that the petitioner is not entitled to any compensation with respect to any vacant land, and thereby he admits that the compensation against the acquired tea bushes bearing land must be given. This position was affirmed by the learned government pleader during Satyendra. During his argument by admitting that if lease is not terminated, the compensation of the lands must be given. As per first clause to section 23 of such compensation must at par with the market value of the land at the date of publication of the notification such and such. Then it is an admitted position that out of acquired 9.41 acres of land, 3.29 acres of land was vacant. That is the purpose for which the lease was given to the petitioner's claimant, that was frustrated so far as the 3.29 acres of vacant land is concerned. Therefore, petitioner claimant is not entitled to compensation against the acquisition of 3.29 acres of vacant land. The lease in question was created for 30 years from 25th day of August 1972. That means the lease was terminated with effect from 24th of August 2002. There is no material on record to show that such term of lease was extended for a further period. We should keep this position in mind in determining the compensation against the acquired tea bush bearing land. The determination of the compensation is above land bearing tea bushes in my consideration should be determined on the basis of the annual lease. The bush bearing 6.12 acres such and such.
But when the acquisition process started, then the lease was subsisting.
Lease was in fact this now I if can my today appeal question the limited is the entitlement of the petitioner so far as the market value of the land. I am not going into any other aspect. I am not also so far as this next page you also will find the what should be the yield of the teas. These are the technical aspect. I am not concerned. Now, kindly, I will only show one document from this paper book and make.
What is the finding that you are not entitled to market?
Yes, that is.
Last sentence of page 46.
Yes.
No, that is claiming yield after.
The petitioner is debarred from claiming yield after 24th August, and also, my lord, he didn't grant me the market any, my lord.
So, according to you, you are entitled to yield after even after 24th August. You are entitled.
And according to me, I am entitled 3/4 of the market value of the land.
Why 3/4?
As per decision of the Honorable Supreme Court.
Where are the findings of the court refusing that?
These are the now the order is at page ordering portion is page 48.
No reason is given why market value is not.
No, they only seek
only this.
That lease has expired.
No, but market value was calculated.
Not calculated
at all.
At all.
But when the acquisition proceeding started,
I had the lease.
Was there?
In fact, today also I am having the lease.
How?
But this is a 6-3 lease. That is why I said that I will stop here. It is, my lord, perpetual in nature. I need.
ওই ডেটের পর থেকে দেবে না বলেছে। না না ভেকেন্ট ল্যান্ড নিয়ে বলছো না সব। 3.29 vacant land you are not claiming for.
Yes, this is a part of tea garden land. Market value I am entitled. So far as the
Lease was granted by whom?
government.
Government.
My lord, your lordship will West Bengal State Acquisition Act. My lord, these tea gardens land were allowed to be retained as per provisions of section 6.3.
Yes.
Now this is the statutory form. The lease is given in the statutory format.
Acha. Lease was in consonance with section 6.3.
6.3 lease. My lord, I'll just show two provisions from the West Bengal State Acquisition Act. If your lordship have the rule also, my lord.
Rule. Yes, probably we had the rule also.
This book contains rules. This doesn't contain rules.
No, this doesn't.
But I have got book, I have only one. In fact, 2 copy, but
He's having that format of lease.
I have annexed the lease also. And the rules contain the formats of this schedule 4. First, you will have to kindly, from the act, my lord, kindly take the section 6.
আপনি না State Acquisition Act rules টা
I have got another book.
আনিয়ে নেবেন রুলস। এদিকে আসুন, সামনে আসুন, ওখান থেকে চিঠি করতে সামনে আসুন। ওয়েস্ট বেঙ্গল স্টেট অ্যাকুইজিশন যে রুলস গুলো আছে সেটা আনিয়ে নেবেন, বা একটা বই আনিয়ে নেবেন যাতে এক বই দুটোই আছে। উনি যেটা দিচ্ছেন, হোয়াট ইজ দ্য পাবলিকেশন পাবলিশিং হাউস?
This is Common Law House.
ও কমল, এটা তো কমল। Which year?
2023.
23টা।
This is also 2023. That contains the rule.
অ্যাক্ট এন্ড রুলস বলবেন, অ্যাক্ট এন্ড রুলস একসঙ্গে বইটা আনাতে কমলেরই আছে। Yes, section 6.3 provides for that.
Yes, my lord.
State Acquisition Act দিন please.
If sorry, sir. Sorry. This is Swastik books. That sorry, sir.
আচ্ছা,
The state acquisition is
যে কোনো পাবলিশারের
this one.
এটাও আছে আমাদের।
আমি দিন এখান থেকে আমি বের করে নেব। Take my book, my lord. I have got 2 copies. Only I cannot show the pages.
Yes. Section 6.3F.
Prior to that, my lord, kindly take. LOC is aware of, my lord, vesting, the general Jomindari abolition. And then 5. Effect of notifications and skipping, my lord, then kindly straightway come to section 6.
PF is the provision.
6, my lord, 2 parts, my lord, 6.1 also relevant.
Yes, 1 also.
I prefer Bear Act now. This book is not Bear Act. Right of intermediary to retain certain lands. Well, it starts with this, my lord, notwithstanding anything contained in section 4 and 5, an intermediary shall, except in cases mentioned in the proviso to subsection 2, but subject to other provisions of subsection, be entitled to retain with effect from the date of vesting land comprises in homesteads, land comprises in appearing buildings, non-agricultural lands, my lord. This continues, my lord, then kindly straightway come to so this is retention, then kindly straightway come to 3, subsection 3.
Yes.
In case of land comprising a tea garden, mill, factory, or workshop, the intermediary, or where the land is held under lease, the lessee, shall be entitled to retain only so much of such land as in the opinion of the state government is required for tea garden, mill, factory, and workshop as the case may be, and a person's holding under a lease shall for the purpose of assessment of compensation be deemed to be an intermediary, provided the state government or this proviso an opportunity of hearing revise any order made by in under subsection specifying land which the intermediary or lessee shall be
Here was
entitled to.
that exercise done.
Yeah, this was done. This was done long
Just
back.
otherwise no lease would be
No
granted.
lease could be granted. My lord, this assessment was made 696 acres were my lord, found to be my lord, retainable by this tea garden. That order, the reference of that order is also there in the lease deed.
Yes, because that had to include this 3.95 also.
Yes, yes, that is an admitted issue. My lord, now kindly take the rules.
Yes. No, okay.
1954 rules, my lord,
Yes.
probably flagged.
Thank you. No, rules start there. We have found the
Yes,
rules.
yes. Rule 4. That will be page.
Yes, rule 4.
Now I am showing it will be
1.6.
rule 4 will be page 1.6 in your lordship's book.
Yes.
Terms and conditions of holding land retained by an intermediary under section 6.1. Has the lordship got it?
Yes.
Any land retained by an intermediary under the provision of subsection 1 of section 6 shall, subject to the provisions of this act, be held by him from the date of vesting on the terms and conditions specified below. No, kindly take A.
A refers to Schedule F.
A refers to Schedule F. Schedule F is not the lease. Now, what the intermediary shall hold such land on the terms and conditions set out in the Schedule F appended to these rules. So, as soon as his assessment is made as per 6.3 that you are entitled to retain this much of land for the tea garden purpose, he is entitled to hold such land subject to conditions under Schedule F. Now, kindly take Schedule F. So, format Schedule F will be page 1.130. Has it also got it? Page 1.130.
Yes.
Land comprising tea garden retained by an intermediary under subsection 1, read with subsection 3 of section 6, shall be deemed to be held directly under the state from the date of vesting as a tenant until a lease is granted in Form 1 appended to the schedule on such terms and conditions as may be specified by the collector in a summary settlement, and thereafter on a lease being granted in Form 1 appended to the schedule on the terms and conditions specified in it. There shall be lease in Form 1 in respect of each of such intermediary, and the same shall be registered numbered by the collector. So first, or till the lease is granted, I am entitled to hold. Then my holding will be subject to the terms and conditions of the lease as per Form 1. Now, Form 1 you will also will find, I will also show my lease deed. Form 1 is next page. No, Form 1, 1.1 33.
Yes.
I'm just keeping all conditions, or kindly straight away come to clause 16. Page 1.139.
Yes.
Let A. That lessee shall be entitled to the renewal of this lease for a further period of 30 years and to the successive renewals for similar period subject to the rules and the terms and conditions of the, and to such other terms and conditions as the state government may from time to time consider it necessary to impose and include in such renewed lease or leases and subject further to such rent as may then be fixed, provided that such additional terms and conditions shall not be inconsistent with the law regarding such lease and shall have retrospective effect.
Your lease was renewed.
I had, my obligation was to submit an application for renewal because this is at the instance of the lessee. But these are the judgments, the renewal, the options to be exercised by the lessee. I had exercised the options, applied for renewal within time. Now the lease renewal came later on.
From retrospectively from that
From that date, it must be. In fact, now the Supreme Court held also that you cannot alter these terms. If it is to be amended, this schedule, this Form 1 to be amended. And in fact, the earlier Form 1
16A says that in fact, provided that such additional terms and conditions shall not be inconsistent with the law regulating such.
Yes. Now what happens, my lord? Time to time Form 1 has been amended. So there is one judgment where if there is an interim sale of transfer of tea garden to a third party.
Yes.
Now after the transfer, the Form 1 has been amended. Now to incorporate salami. The Supreme Court held that
the expired period, no.
No.
That's the law.
That's the law. After the expiry period, this amendment will come into force and the transferee shall be liable to pay that salami. So I need to show that I had applied because this has been held by many other cases, my lord, is perpetual in nature. As long as, my lord, I wish, the lease will be renewed. And it cannot be also, my lord, by whims of the government, it cannot also be resumed. This is a tea garden. Unless I have committed any breach, a proceedings has been initiated, a lease is terminated, it is at my whim. Now kindly take, my lord.
So you produce those documents that has been
yes,
for...
that's why. My lord, my lease deed you also will find that was also exhibited. Lease deed is part 2, my lord, page 12. That was referred to by the learned judge itself. In Form 1, you also will find the clause 16 also, same clause. Part 2, page 12.
And where is the extension application?
Why I am saying so, kindly take page 12 top. Exhibit 8, has you got it?
Yes, yes.
Now it refers to certified copy of registered deed of lease executed between the governor's statement and dated 28 September. Now, I'm just giving
the extension application.
But kindly take the assessment. This has been referred in this. Now kindly take the last page of this document. I'm sorry, my lord. Yes, my lord, kindly take schedule 1, page 21. I'll come back to 16, clause 16.
Yes.
The last district Darjeeling PS, has you also got it? Toji such and such, comprising an area 696.10 allowed to be retained by geo number such and such, dated such and such. So this was the assessment as per section 6.3. And on that basis, this retention order was there. Now kindly take 16, page 20, just 20 bottom. Page 20, just immediately preceding page.
Yes.
Act 2.
Yes.
Better. That lazy shall, after fully observing and performing the terms and conditions of these,
So it's a copy paste of the statute.
concern be entitled to the lease for a further 30 years. It is just, I mean, bolchi to.
Be entitled to the renewal. So it's your option.
So my duty was to apply for the renewal before the expiry. The expiry was sometimes in August 2002. My lord, kindly take page 24.
Yes. Yes.
This is my application for renewal. It was dated, my lord, 21st of March 2002. Bottom left. It was received also on that same day.
Received on that date.
Date
The caption says exhibit 9, 16th
16th
March.
March 2002. So this was the application for renewal. Now the renewal came later on, my lord. I have got the lease with me. The application. The lease was renewed ultimately, but it is always delayed. On 30th day of May 2014, with retrospective effect from 24th of August 2002. আরে আমার অ্যাপ্লিকেশনটা এখানে নেই, দেখ আইপি মুখার্জির একটা অ্যাপ্লিকেশন, সরি, ঠিক আছে ঠিক আছে ঠিক আছে, আপনি দিয়ে দিন ওটা। This has, I had also brought to the record, I had filed an application IA2, kindly take 2022 to bring in on record the order passed by the Honorable Supreme Court, where I have annexed this lease also.
We'll see from there.
Yes, IA2. It has also already been disposed of, but it is there in the record. 2 of 2022.
এইটা কেটে দিন।
Disposed of হয়ে গেছে, আছে তো রেকর্ডে।
Just কেটে দিন।
হ্যাঁ হ্যাঁ।
এইটাও এটা।
Also got it. Page 12, it starts. Now the relevant portion is at page 14. Form 1, Schedule F, you also will find. You will also find the date. The second paragraph, witnesses that in consideration of the rent such and such to be paid and or the lessee, the land schedule subject to the reservation specified in schedule 2 for a term 30 years from 24th August 2002. Has you got it?
Yes.
So my obligations was in this 6.3 lease in Form 1 under Schedule F, The learned judge was not right in saying that my lease stood terminated on expiry of the after August 20 or 2002. Because it was perpetual in nature. And he was obligated under law to assess the market valuation. That is one aspect is who will get the compensation. That I come on later, madam. But he need to assess the market value for the land to be acquired. That is 23(1), section 23 of the.
Court committed two errors as of now. We have seen one is that lease was continued, but that was not taken into account, holding that your lease has terminated, and that was the premise for not giving you market value. One. Secondly, vacant land was excluded. The court read a second agreement into the agreement. The lease deed has no such provision, and the court was not deciding on the validity or whether you have complied with the lease or whatever.
That was not the aspect at all. I need to show two things. One, my lease deed, and that I had applied. And I had this acquisition notice came in 1999.
Yes.
But even if, for the sake of argument, that as on the date of acquisitions, I had 3 years left in the lease. So the land judge was required to assess the market value of the land. Even then he will calculate that what will be the quantum I will get because of the residual period of 3 years. But he cannot say that since it was expired in August that you are not entitled to the market value. Kindly take section 23(1) of the Land Acquisition Act.
Yes. Rate of publication. Obviously.
Market value of the land on the date of publication of the notification. And he completely, both the collector ignored, the reference court ignored. And the landed judge has no authority to say that he cannot go into the lease. He cannot say that I was not using the land for the tea garden purpose. In tea garden, it requires a play garden for the laborer. It requires the quarters. It requires the factory. So entire land cannot be used for the plantation. It's absurd. So there may be vacant land which could have been used for the play garden of the laborers who are employed therein. Because this assessment was done by the state government according to my requirement.
Exactly.
Now, what as a lessee I am entitled? There are subsequently 2 judgments which are required for this purpose. One is Indar Kumar, this is 1994, followed in Bridge Bhushan Sayas case. A short notes probably
was given, yes.
Brought the record before the earlier division bench.
It contains those, yes.
Yes. The judgments most probably contain 2 pages.
Tandon Brothers is there.
Tandon Brothers is there. Tandon Brothers was for the scope of 6(3) leases and others. Tandon Brothers, paragraph 15, I am relying on. That is the scope of 6(3). Justice there has got. May I hand up extra copy?
Page 4
So far that concerned. So far the Tandon Brothers is concerned, but with regard to the scope of section 6(3), I have been relying on paragraphs 14, 15, and 29. So kindly just take a note. Now kindly take the next judgment. Page 25, Indar Prasad. Kindly straight away come to paragraph 5.
Judgment.
Page 25,
Indra Prasad, yes.
running page 20. Paragraph 5. These principles is still followed in the Supreme Court. Earlier, there was a question whether the government needs to acquire his own land where it has been a lease has been granted for such land to a third party, or the government can straight away take it. It is my land.
Resume.
Now, kindly take. Paragraph 5. In this case, admittedly, government being the owner of the land, the appellant held the demised land as lessee, with superstructure built thereon, and was in possession and enjoyment of the same on the date of acquisition. The contents of the award extracted herein before clearly indicate that the land acquisition collector could not determine compensation payable towards the leasehold interest held by the appellant. Being an owner, the government is not enjoined to acquire its own interest in the land or land alone for public purpose. When its land is granted on lease in favor of a lessee, its power to resume the land is subject to the non-fulfillment of the terms and conditions of the lease by the state, lease by the lessee. So long as the lessee acts and compliance with the covenants contained in the lease or the grant, the right resumptions in terms of the lease or grant would not arise. But when the land is required for the public purpose, the government should get absolute title thereof free from all encumbrances. Compensations become payable for the leasehold right or interest held by the lessee or grantee when the land is acquired. The point becomes clear from the following illustrations. I am not then may I continue reading? This is interesting. The point becomes clear from the following illustrations. Take a case where the government granted lease of agricultural land on annual payment of rent with a covenant that the government is entitled to resume the land when needed for public purpose, or as when government finds that the land is required for public purpose. In terms of the covenants, the government is entitled to exercise its option to determine the lease through though the lessee has been complying with the conditions and payment of annual premium of rent and resume the land in accordance with the terms of the grant. No such clause in this lease. In that event, the need to take recourse to acquisition and make compensation does not arise. Take a case where the government granted the lease of the open land with the permission to the lessee to construct a building for his quiet enjoyment with appropriate covenants, and the lessee with permission constructed the building, and by complying with the covenants of the lease was in quiet enjoyment. The self-same property, when required for public purpose, government cannot unilaterally determine the lease and call upon the lessee to deliver the possession. Therefore, the government is required to exercise the power of eminent domain. By invoking the provisions under the Land Acquisition Act for getting such land, the collector shall have to determine the compensation toward the legal interest held by the lessee if accessible separately and determine the compensation. The owner of the land, the lessee being the owner of superstructure and government being the owner of the land, if compensation is determined for both the components, then the same has to be apportioned between them. At what portion the lessor or lessee are entitled to receive compensation has to be determined the respective shares at which the compensation is to be apportioned between government and lessee. The course open to land acquisition character is to determine the total compensation, make an award, make a reference to the civil code under section for decisions of apportionment. Exactly that is the situation of the fact that take another illustration, the government grants a patta of its land subject to payment of land revenue. Later, the land is required for the public purpose. The payment of land revenue is at par with the payment of land revenue payable by a private owner to the by grant of patta. The title has been vested in the grantee. Therefore, grantee is entitled to full compensation. Now, in this case, it has been held. Kindly take last page, paragraph, the last portion of paragraph 8, page 30. The High Court. Has got it?
Yes.
Running page 30.
Got it.
The High Court, by its judgment and decree under the present appeal, has modified the apportionment of the compensation payable for land as 75% for the lessee and 25% for the lessor. Under these circumstances, it cannot be said that the land acquisition character had determined the compensation only towards the leasehold interest held by the appellant, and that therefore the appellant is entitled to the entire compensation determined by the collector. I've never claimed that I am entitled for the entire compensation, although I can stretch such argument, because this is under 6C. Now, the Land Reforms Act has been amended. Now, whether I am a non-agricultural tenant or not, that is a question. In fact, it was decided by the division bench of our High Court, presided over by the Honorable Justice Sheth. Now, that has been virtually set aside by the Honorable Supreme Court, remanding only on the ground that this issue was not before that Land Administrative Tribunal. Now, the tribunal is sitting over that matter. Once I also appeared there, sitting over the matter, most probably from 2010 onwards. So now, by virtue of the amended provision of the Land Reforms Act, these lessee can claim that they become virtually riots, because these leases were all perpetual in nature. And resumptions, initial judgments, the resumption provisions, it was amended. Initially, it was said that only if it is found that this land is no more required for the tea garden, only that portions can be resumed by the, or it can be, the order can be, 60 order can be revised and modified to that extent. That too, the Supreme Court found that you cannot assess. It is to be, in that fashion, it is to be assessed at the first date. Now, subsequently, that has to be amended. You will also take the estate acquisition, I just show the amendment. Because of the Supreme Court's judgment, delivered by Honorable Justice Umesh Chandra Banerjee, as it lordship then was. Kindly take section 6.3 proviso.
Revision.
Yes, there is an amendment. I'm just pointing out the amendment. Sorry, my lord.
Yes.
Explanation 2. Kindly take proviso explanation 2. This was added, and this amendment was brought, my lord, in 2010. After that judgment was probably delivered in 7 or 8. This explanation 2 was added after that judgment of the Honorable Supreme Court. Ki naam ta jano? Judgment. After this judgment only, these Tandon brothers I have annexed. This amendment, this explanations 2 was added, my lord.
In your case, Mr. Bandhavade, you are restricting your claim to.
The last judgment, my lord, now this has been reiterated by the Honorable Supreme Court.
So you're restricting your claim to the
market value of 3/4. I had said.
Why 3/4?
75% as a perpetual lessee. This has been done by last judgment, Bridge Bihari Sahaya versus State of UP, 2004 1 SCC, running page 31, my lord. The kindly take paras 20, 21, and 22. Now, this was Inder Prasad was relied on, and 75 and 25 it was apportioned in this long-term lease or in perpetual lease. May I just read? হঠাৎ করে মামলা নিয়ে এলে এরকমই হয়। Running page 48, paragraph 20, may I start?
Yes.
The claim.
Yes, yes.
The claim on behalf of the appellant that the entire compensation determined was only in respect of the totality of the rights held by the appellants as lazy and not to the whole inclusive the rights of the interest of the government also. Though appears to be attractive, does not appeal to us for acceptance. Though as a matter of principle of law, the government, while invoking the provisions of the Land Acquisition Act for acquiring land in which government also had some or other interest, need not go for acquiring their interest as well. What is permissible as well as obligated for acquisition is only such of the private interest of the third parties other than that of the government. The land acquisition officer in this case has chosen to, while determining the market value, indiscriminately proceeded to determine for the whole of it, and only as a consequence thereof has chosen to apportion compensation between the government and the claimants at the rate 10 annas and 6 annas respectively. Though the reference court during the course of his judgment adverts to the principles relating to the need or desirability of acquiring land of only private parties other than the government under the Land Acquisition Act, has ultimately chosen to adopt only the standard rate of market value determined by the land acquisition officer. Consequently, niceties of language apart and the purported endeavor attempted to have been made by the reference court, we are constrained to hold that the actual market value determined was that of the acquired properties as a whole, and consequently the need for apportionment would inevitably arise. Here it has not been assessed at all. Then 21, applying the ratio of the decision of this court reported in Inder Prasad's case, the fixation of the apportionment at the ratio of 75% in favor of the claimant and 25% state would be just and reasonable. The ratio fixed seems to us to be more appropriate on the facts of this case than one approved in Ajit Singh's case, having regard to the fact that the government interest has been fixed 25%. Now, kindly take the terms of the lease period in the present case. Kindly take
But Inder Kumar, the court relies on Inder Kumar
yes,
to say that we are following the ratio there and putting it at 75%.
75%.
Inder Kumar did not lay down such a ratio. Please come to page 30 of your compilation.
No, it was not. It said that was
that
also
case High Court.
That was the it affirmed.
Yes, but it was never held that there has to be a fixed
No,
formula.
but this has been followed. In subsequent other judgments also same thing has been followed.
But ratio was never laid down that this should be the maybe a rule of thumb. Rule of thumb.
Yes. But because now who's in
the Kumar court said that the High Court by its judge under these circumstances, in that case it was determined at 75% for the lessee.
This was followed in the subsequent Bridgeberry Soya also. The 75%, 25%.
Then no logic to it. Why 75? Why not 80 or 60?
My lord, it should be 3:1. My lord, that was the principles.
There is no principle laid down anywhere.
That because now
all follow Inder Kumar.
Why
Inder
I am
said High Court
why
in that
I am
case said.
Why I am saying there is no specific ratio is laid down, but I am the lazy having perpetual interest. And I was the tea garden, tea estate. I was using the land. Government could not have
yes, in the light of section 6(3),
it could not have.
Mr. Bandhav, if you have a right of perpetual lease, perpetual renewal, then why should the government get anything?
get it.
Get anything.
Get anything. That would have been, my lord, because it has been granted, my lord. At least I have just annexed 2 cases. There are other cases where also the government, some portion has been given to the government.
But we don't see any ratio was ever laid down as a principle of law. That for
Can
this
we
reason,
take,
yes. Because in Inder Kumar case,
can
we
I
don't know what was
take
the
paragraph
application.
3 of that this judgment, my lord?
Paragraph 3.
Paragraph 3. I'm just showing you what. Paragraph 3, page 36, my lord.
So we will continue with this after the recess.
Yes.
Continue.
Here, my lord, it was the
We'll
way.
start with this after the recess. We'll start with this. Yes, go on.
My lord,
Para 3.
Lord, kindly take, my lord, just for the time being, my lord, skip paragraph 3, kindly straightway come to, my lord, paragraph 16 again. Because it is, the facts have been reiterated in paragraph 18 also.
Yes.
But while referring Inder Prasad, the court said this court, while dealing with the compensation payable and apportionment of the same between lessee and the owner of Najul land owned by the government itself, but given on a perpetual lease by the government with right of re-entry on the breach of covenants, when being acquired under the provisions of 1994, held that fixation of the proportion should be 75%. Then, my lord, 17. The other judgment which has been referred, in Union of Ajit Singh, a bench consisting of 3 landed judges while dealing with the apportionment compensation between tenant and landlord on the land being acquired under the land acquisition in respect of government land held by a tenant under a lease for 30 years with a right to further renewal up to a maximum period of 99 years. As well as you got 17.
Yes, yes, yes.
It was given held 60% to the tenant and 40% from the landlord. Then, my lord, in the present case, it was found that it was more of a grant. So, but the government has interest. So, again, also in this case, the Supreme Court approves 75% for the tenant and 25% for the government interest.
No.
Now, in our case, we didn't claim 3:1 or as per statement of claim, we straightaway claimed market value.
We failed to find any ratio being laid down in the court. That is our problem.
No, there is, if you lordships put these questions to me, that will be my problem also. Now, no specific ratio has been laid down.
How do we,
but your lordship kindly just compare in 16 Inder Prasad, it was a perpetual lease. The court said,
no, facts of Inder Kumar court also said in this Judge Bijmohan that the facts of
75%?
those are more applicable
Yes,
there,
70.
which is applicable to your case also.
Yes, yes. And the 17, it says up to maximum period is 99 years. Then the court said 60-40.
The High Court's judgment in Inder Kumar would be very relevant here, probably. But we don't have that, so no difficulty.
No, I don't have Inder.
No, how can we have that?
Because if it is reported, then I can have it.
Exactly. How do you have?
Now, these, paragraph 18, you will also find the fact of the present case.
And if you please come to paragraph 2 of Inder Kumar 1, page 27, running page.
Yes, yes. Paragraph 2.
Paragraph 2, page 27.
Yes.
Before paragraph 3, the district court by
District
judgment.
Court by judgment dated 15/19 held that the government and the appellant were entitled to compensation at the proportion 33% and 67%.
Now, then please read on.
On further appeal by the appellant, while upholding the title of the compensation by the government and the appellant, the High Court altered the proportion to 75% and 25% between the appellant and the government respectively. So it is from 60.
The next sentence. The
government did not question the said proportion at which the compensation was payable to the appellant.
Therefore, it was the government conceded. Government did not object to that. And that premise, Supreme Court held that yes.
No, the appellant being agreed for the approximate 25% compensation in favor of the government filed this present special leave petition.
Yes.
So that the Supreme Court said, no, it was rightly done. That was the final, yes, 25% for the government. That is the last paragraph. Supreme Court only affirmed the order of the High Court.
No ratio. Anyways.
Well, what these land acquisition cases, your lordship will not find a specific ratio. What the Bridgemotion Shire did, he considered 4 judgments. 2 relates to perpetual lease, 1 relates to a limited lease of 99 years, and he accepted the views of the Supreme Court that when there is a limited lease of 99 years, it was 60-40, but in respect of a perpetual lease of perpetual nature, the Supreme Court affirms 75%, 25%. So that becomes a precedent. It's not a specific ratio that only because this is a perpetual lease, 75% to be awarded. There's no such ratio. I didn't find. Well, in fact, there are certain arbitration cases under the Requisition and Acquisition Act before Justice Probir Kumar Samanto. Well, he happens to be quite knowledgeable in
Yes,
this.
yes,
But he also failed to.
Remember the judgment of Justice Samanto that 999 years lease
Yes.
equivalent to ownership.
So at
Justice
least
Samanto, what was his view?
view is 75%.
Following these judgments.
Following these
It is always convenient for the court to. Let
His
us not
view
go
was
into
75%. So that, but in the statement of claim, and this order is also somewhat peculiar. Kindly take my statement of claim, not statement of claim, reference, because there is no statement of claim so far as this reference petition.
It was given to someone else. The compensation was paid to someone else.
Nobody. It is still with the collector.
Great.
Because the petitioner did refuse, then 18 reference, no payment as yet. In fact, it was not even tendered. It is to be deposited. Section 31 of the, it is to be deposited with the reference code. It was not even deposited in the reference code. Now the law has been completely altered in Indar Prasad. Otherwise, it should have, the order of the division bench was correct in there.
You probably can also claim interest on that then. You'll have to consider that. But that is provided in the statute, whatever it is.
That is statute, it has been provided, but it was not deposited. It was mandatory required under 31. Under the Land Acquisition Act 1, it was to be deposited.
What is your statement?
The reference petition. My lord, kindly take from paragraph 10, page 3, page 2, it starts most probably. Page 1 of the paper book. The relevant is page 4. Page 4 from paragraph 9 onwards, the what amount land, then 10. The claimant submits that the life of tea bushes in that local area is about 80 years and continues to yield good tea for about 60 years.
Tea bushes was given to you.
This is the loss he assessed. So he would deprive from the tea business in the. This will have some relevance so far as the order is concerned. Well, that is why I was showing that he assessed the loss of profit at 78 lakhs and something. Then he claims, paragraph 11, considering the prevailing market price of the vacant land in the locality to be 3 lakh per acre, the value of 3.29 of vacant land within the acquired land is 9 lakh something. And total then, the market value. Total
the entire
12 is entire market value is
75%.
91 lakhs.
You did not claim 75%.
No, I didn't claim entire. This was, now kindly see the schedule at page 6. The claim, page 6. Now kindly take. First is damage sustained as per 4th clause of 23(1). These are the factors. Now the 7th is as per the West Bengal amendment. The 7th clause is this 78 lakh something. That is the loss as per 7th clause. Now, if you look at the book Land Acquisition Act, most probably in this book it will not be available. This is a state amendment, West Bengal amendment. Kindly take my book.
It is there.
West Bengal amendment is there. 7thly, in section 23.
Just check.
Up to 6thly, you will also find. 23(1).
Yes, separately given.
7thly. It is there.
Is given.
Yes. Now kindly take first market value, second damage sustained by the person interest, thirdly the damage even sustained, and not fourthly the damage sustained sustained by the person interest at the time of collectors taking possession of the land by reason of acquisition, injuriously affecting his other property, because what the petitioners claim that a portion of the tea garden, this land was acquired for the purpose of approach road to the Bagdogra airport. You is well aware. The approach road, that is from this tea garden. That was acquired. Now the tea garden has been bifurcated virtually. So that creates loss.
Irrigation system or problem.
Because the entire thing has been
Becomes two separate establishments.
two
Sort of.
separate
Yes.
establishments.
You have to maintain each separately.
Irrigation's problem, the access
Irrigation is
problem,
maximum because
access problem.
there's a culvert and there's no
So
culvert.
that is why this fourth, now the seventhly, last. Seventhly, loss of earning, if any, cause to the person interested in consequence of the acquisition of the land where earning was derived directly from such land. That was the West Bengal amendment.
Yes.
And that 78 lakhs was claimed as loss of earning. That was the yield. Now, what the learned judge did, he assessed the loss of earnings for 3 years, because 99 to 2002, and said this is the market value of the land. Kindly see the order.
Page 47.
No, kotha theke shuru hocche? Yes, 46 again.
47.
Okay. Kindly take 47.
Market value of the property land was not given at all.
Not assessed at all. What he assessed, kindly take page 47 after 8 line.
Yes.
It may also be mentioned here. Has you lost it?
Yes.
Got it? Huh? It may also be mentioned here that the annual yield from 99 to 2002 may be taken as same per year. There was little possibility of much difference in yield in such period of time, considering the productive life of tea bush. Now, in the first case of tea bushes planted in 72, the annual yield is such and such approximately, and the second case of annual yield is such and such. That is, in all, such and such. The total value of such annual yield is such and such, 5,000 something kg and plus, and the net income after 50% deduction was this much. The total annual income for 3 years from August 1999 to August 2002 is such and such. Therefore, the compensation as per market value, which ought to have been awarded against the acquisition of 6.1, becomes this much.
So market value of land has not been given at all. One.
At all.
Secondly, market value for the period after 2002 has not been given.
No, that was the loss of profit.
Loss of profit. Seventhly,
that
has
was
not
he assessed up and given only for 3 years.
So these are two grounds on which you want to set.
Now, so far as this matter is concerned, it has a certain, it has some history, checkered history. But most probably,
and also vacant land was excluded. You also want that
excluded, because market value it should be calculated on the
entire
for entire. What happens there? But against the order of the reference court, the state preferred an appeal. Now that appeal, in that, despite directions of the court, there was a direction for filing of paper books. Now in that appeal, we filed the cross objections. Now that the state did not comply with the directions, and by default their appeal stood dismissed. Now our court was converted into the first appeal. That is now this. Now, while it was being heard before the Honorable Justice Soumitra Pal, as his lordship then was, somehow the state appeared and state's appeal was also heard. And it was heard. Now, you also will find the subsequent orders also state appeared in all cases. They never proceeded, they never argued their case. Today also they are absent. Repeatedly we have served, in fact, we have filed the written notes. We completed our submissions before the Honorable Justice Showman Shen, as it then was. This is the positions. Now I am suffering from 1999, and no payment at all as yet. And I cannot, today demand that your lordship should assess, because it cannot be assessed, because market value is to be first assessed by the reference court.
We have to pass a judgment. If we win this appeal, we can only formulate some points. Market value for entire land, 75% of that. Market value of the entire period, that not
the loss
Yield if
Yield.
loss regarding yield is the entirety has to be paid to you. There is no question of 75% there. After 2002 also, and for the vacant land also. So these are your three.
These are the three things. Now, because I cannot lead evidence here today, market value velocities cannot assess.
No.
In my
Documents are to be seen.
There is no
Supreme Court-
document.
Supreme
I
Court-
do not find any document.
Supreme Court.
There is no judgment of the Supreme Court where it.
In this case, it did not go up to the Supreme Court. It went up to the Supreme Court.
It went up to the
That-
Supreme Court
that-
only on the limited issue.
Where is that? Which page is that?
That is in the application.
What's in the
I
application?
have annexed on that order.
Right.
Page.
Yes, in the application reform.
You'll also find the new lease. I have just shown.
New lease, yes, yes.
Then the order is last, Malad, page 41 of that.
Yes.
I am confining to my argument only with regard to the Malad validity of the reference code order as per Act 1 of 1994. I am not coming to 2013 Act.
Inder Prasad and the last judgment you have cited only for the purpose of this Rij Bihari, you have cited for the purpose 75%.
Yes. Both 75%.
Yes.
Otherwise, before the reference code, I claimed for the entirety as a perpetual leasing.
Despite service, none appears for the respondent state.
Tandon Brothers I had cited only to show the scope of section 60.
None appears for the respondent state at the time of call. So accordingly, the appeal is taken up for hearing expert. এর আগে একটা portion শুভ্রকে দিয়ে
Airport authority appeared.
Next para. Airport authority in a previous portion of this order.
Oh, as you must have recorded.
Next para. There are senior counsel appearing for the appellant stroke land loser argues that the reference code, comma, while passing the impugned judgment, comma, failed to calculate market value of the land as a component of compensation, comma, thereby giving a go-by to the first component of Section 23 of the Land Acquisition Act 1894, within bracket, for short, the LA Act, bracket close. Question. Next para, secondly, comma, it is argued that the reference code, comma, while calculating compensation, comma, omitted to include a portion of the subject property, comma, which is in the nature of a tea garden, comma, which was lying vacant, comma, from the calculation of compensation. First up, it is further argued that the learned reference code granted loss of earning, comma, as incorporated in Section 23 by the West Bengal Amendment of 1963, comma, only up to the purported date of expiry of the lease which was granted in favor of the appellant. However, comma, it is submitted that the lease was granted under Section 6 within bracket 3 of the West Bengal within the contemplation of was granted within the contemplation of Section 6 within bracket 3 of the West Bengal Estate Acquisition Act 1953, comma, read in conjunction with the West Bengal Estate Acquisition Rules, comma, 1954, comma, in particular Rule 4 read with Schedule F and Form Roman I thereof. Next para, thus, comma, since in terms of the said provisions, comma, the lessee stroke appellant had an unfettered right of renewal in perpetuity, comma, the appellant only had to show that an application had been made within the prior to the expiry of the original lease which was granted to the appellant. Full stop. By placing reliance on the annexures to Can 2,
Evidence I have given, my lord, the application.
yes, sorry, by relying on the annexure. It is pointed out that an application for renewal, which was filed well before the expiry of the original lease, was also a part of the evidence before the reference court. Full stop. In terms of the said application, the renewal would be quasi-automatic. Full stop. Next para. In fact, subsequently the application was granted and a fresh lease has been executed in favor of the appellant, which is annexed to GA2 of 2022 filed in connection with the present appeal. Full stop. Next para. Learned senior counsel cites such and such reported Tandon Brothers reported at 2001 5 SCC 664, where the Honorable Supreme Court laid down the scope and parameters of a lease within the contemplation of section 6 within bracket 3 of the 1953 Act. For some next para, learned senior counsel further cites
Index was given.
Pardon?
One index was there of the written notes.
Inder Prasad such and such reported at 1994 5 SCC 239 and Brij Bihari Sahai reported at 2004 1 SCC 641, where the Honorable Supreme Court held that in cases of lease such as the present case, the compensation in respect of the market value of the land should be apportioned in the ratio of 75:25 respectively between the lessee / land loser and the government. Full stop. Next para. Learned senior counsel next contends that it was not for the reference court to adjudicate on whether the appellant used the entire let out property for the purpose of tea gardens. Full stop. However, transgressing beyond its jurisdiction, the reference court took into consideration the purported non-use of a vacant part of the property in terms of the lease. Full stop. It is further submitted that the reference court erred in law and in fact in assuming that the said vacant portion of the subject property was not appertinent to the tea garden. Full stop. Next para. Learned senior counsel places reliance on section 23 of the LA Act, as amended in West Bengal, to reiterate the contentions in respect of market value. Full stop. Next para. From a bare perusal of the impugned judgment, we find substance in the arguments of the appellant. Full stop. Next para. The matter has a checkered history. Full stop. Initially, a notice under section 4 within bracket 1 of the LA Act was published in respect of the subject property on May 7, 1999, was issued on May 7, 1999, which was published in the official gazette on May 20, 1999, thereby initiating the process of acquisition. Full stop. Next para. Subsequently, in view of the appellant being entitled to retain the suit, retain the subject plot, which is a tea garden, within the contemplation of section 6 within bracket 1 within bracket small f, comma, read with section 6 within bracket 3 of the 1953 Act, comma, a lease deed was duly executed, comma, which was due to expire after 30 years, that is on August, what is the date? 22nd.
It was already there. 78 was the lease deed, 99 was the acquisition notice. The lease was subsisting.
Achha. No, what was the outer limit?
It is
2002, which date?
20th August.
Achha. On August 24, 2022. 2002. August 24, 2002.
Yeah. Lease was of signed 1978.
Achha. No, you said that the lease was granted in terms of the of section 6.3
in 1978 first. It is continuing. The second, the renewal came in 2000.
Yes. Full stop. Next para. Thus, comma, at the juncture when the acquisition process was initiated, comma, the lease was already subsisting. Full stop. Next para. Hence, comma, by default, comma, the first component enumerated in section 23 of the LA Act would be applicable, and the reference court, as the collector as well as the reference court, had to calculate the market value of the land at the date of publication of the notification under section 4 within bracket 1. Full stop. Next para. Secondly, comma, the learned reference court proceeded to refuse to calculate the market value of the land on the premise that the lease of the appellant was due to expire on August 24, 2002. Full stop. Next para. However, comma, we find from the materials on record, where is that extension application, the page number for that?
Page 20, page 24.
Yes.
Of part 2.
That an application for renewal of lease was made by the appellant on March 16, 2002, comma, which was received by the concerned authority on March 21, 2002. Full stop. Next para. A comprehensive reading of section 6 within bracket 3 of the 1953 Act, along with Rule 4, comma, read with Schedule F and Form Roman I thereunder of the 1954 rules, clearly indicates that in case of such statutory leases, comma, the right of renewal of the lessee is in perpetuity, comma, subject to the limited rider that in the event the terms and conditions of the lease are violated by the lessee, comma, the state would be entitled to re-enter stroke resume the property. Full stop. It may be noted that in the present case, comma, there is no whisper of any contravention of the terms of the lease by the appellant from the end of the state. Full stop. Thus, comma, merely by dint of the application for renewal of lease before its expiry, comma, a valuable right accrued in favor of the appellant of renewal of the lease for at least a further period of 30 years. Full stop. Next para. In any event, comma, from the documents annexed to G8, CAN 2 of 2022, we find that a fresh lease was actually granted pursuant to such application for renewal, comma, with retrospective effect immediately from the expiry of the earlier lease. Full stop. Such lease, comma, it is to be noted, comma, is still subsisting. Full stop. Next para. Hence, comma, at all relevant points of time, comma, the appellant was a lessee in respect of the subject property. Full stop. Thus, comma, the reference court committed a perversity by refusing to calculate market value of the land as on the date of the notification under section 4 within bracket 1 on the erroneous premise that the appellant was not a lessee. Full stop. Next para. On the other aspect of the matter, comma, the appellant is justified in contending that it was beyond the jurisdiction of the reference court within the limited scope of section 18 of the LA Act, comma, which is confined to the enhancement of the quantum of the compensation, comma, to interpret the terms of the lease and to come to a conclusion that the appellant had violated the lease by not using a portion of the property for the purpose of growing tea bushes. Full stop. Next para. Nothing in the lease deed contains any term that no portion of the tea gardens could be left vacant. Full stop. In fact, comma, there might have been umpteen reasons as to why a portion of the tea garden was kept vacant, comma, technical or otherwise. Full stop. In any event, comma, since there is no allegation of violation of the lease, comma, the referral court acted without jurisdiction in interpreting the terms of the lease and rewriting the agreement between the parties by refusing to grant compensation by calculating market value of the purported vacant area within the tea garden. Full stop. In terms of section 23, comma, it was for the referral court to calculate compensation on the basis of the market value of the entire land, comma, including the vacant portions thereof, as well as the portions which were used for growing tea bushes and or otherwise. Full stop. Next para. Insofar as the computation of loss in terms of the seventh component of section 23, comma, as amended in West Bengal, comma, the referral court also committed a patent error of law by calculating such loss till the date of expiry of the original lease, that is August 24, 2002. Full stop. Next para. Full stop. It is quite surprising that such calculation was made only from August 1999 to August 2002, comma, evidently for the remaining period of the original lease. Full stop. However, comma, in view of the above findings that the lease of the petitioner was all along subsisting during the relevant period till date, comma, the calculation of the loss ought to have been based on the yield for the entire period. Full stop. Next para. Insofar as the computation of compensation is concerned, comma, the Honorable Supreme Court, comma, in Bridge Bihari Sahai, এটা হচ্ছে 2004 এরটা, comma, took into consideration the discussion in Inder Parshad 1994 5AC. Inder Parshad, and under similar circumstances, comma, held that the compensation payable for land to the lessee stroke land loser would be 75% of the total payable compensation, whereas the rest 25% would go to the lessor within bracket the state, bracket closed. Full stop. Next para. Although we do not find any clear reasoning for coming to such conclusion, comma, in view of the Honorable Supreme Court having consistently followed the ballpark figure of 75:25 ratio of compensation for the lessee and the lessor respectively as a thumb rule, comma, we also follow the same and hereby come to the conclusion that after computation of the entire compensation payable for the total
Sorry,
land
market value, because the other parts is loss of, these are payable only to the lessee.
on the basis of the market value
Ah.
of the land, comma, it would only be appropriate if 75% of the market value of the land, comma, in respect of the first component of section 23 of the LA Act, comma, would be payable to the appellant. Full stop. Needless to say, comma, insofar as the other components of compensation are concerned, comma, those would be paid in their, those are to be paid in their entirety to the appellant. Full stop. Next para. In view of the above, comma, FA 77 of 2012 is allowed, comma, thereby setting aside the impugned judgment and impugned judgment and decree dated October 23, 2003, passed by the learned Additional District Judge, First Court at Darjeeling, in what was the number of the LA case number 2 of 2000.
Reference case.
LA case number 2 of 2000 and remanding the matter to the reference court to compute compensation on the basis of the following yardsticks. Colon দিয়ে নিচে Roman 1 full stop. Insofar as the first component of section 23 of the LA Act is concerned, comma, in respect of the concerned, comma, the referral court shall calculate the market value of the land at the date of the publication of the notification under section 4 within bracket 1 of the said act upon granting opportunity to all both parties to furnish evidence in that regard and stroke or upon calling for reports in that regard from the appropriate authorities as to the contemporaneous market value at the juncture when such notification was issued. Full stop. Out of the same, এটা 1 চলছে, Roman 1. Out of the same, comma, 75% would be awarded as compensation to the appellant, whereas the rest 25% shall be awarded in favor of the state. Full stop. Roman 2. Insofar as the other components of section 23 of the LA Act are concerned, comma, that is from the second to the seventh component within bracket as introduced by the West Bengal Amendment bracket closed, as well as the components incorporated in subsection 1 capital A and 2 of section 23, comma, the same shall be calculated for the entire period as provided therein without limiting the same to the to August 24, 2002. Full stop. Roman 3. Now, the said amount shall also be granted as compensation to the appellant. Roman 3. While computing the market value for the land as directed in Roman 1 above, comma, the referral court shall take into account the entire subject land, comma, including the vacant lands, and compute the market value on such premise for such entire land, comma, which will be the basis of the compensation to be granted under uh, serial number 1 above. Anything else?
The only thing, since the whatever already you also have set aside, I should have asked them to pay without prejudice. That I am, because it will be enhanced.
No, nothing has been paid, you say.
Nothing has been paid.
So the amount directed by the collector should be paid to you. Only that before calculation, how can anything else?
Yes, that is the problem.
The aforesaid, the aforesaid exercise are Roman na. Ebar tarpore emni para. The aforesaid exercise shall be concluded as expeditiously as possible, comma, preferably within 6 months from the date of communication of this judgment to the reference court. Full stop. Next para. The reference court shall also direct disbursement, immediate disbursement of the amount calculated by the collector in favor of the appellant, comma, without prejudice to the rights and contentions of the parties. Full stop. Such payment shall be made as expeditiously as possible, comma, preferably within 2 months from the date of communication of this order to the referral court. This much. The pending connected applications, 1 is also pending.
No.
Only 2 is pending.
Nothing is pending. 2 is
Oh, that was also disposed of. Very well. Ar kichu na? Interim order if any stands vacated, no address to cost, urgent certificate.
You'll also kindly grant liberty, otherwise they may take this point. In the earlier order, they said airport authority. Now it is going back to the referral court, so they may have some right to place evidence.
Very well.
That the first portion of the order you will also have recorded. Section 50 as such. Otherwise, they said that the
Very well. No address to cost age tar age ekta kore debe.
they may come.
Yes. It is made clear that while making such computations as directed above, comma,
You will also kindly grant them liberty. Otherwise, it
the requiring the Airport Authority of India, comma, for which the acquisition took place in the first place, comma, will be at liberty to appear and adduce evidence before the referral court for the purpose of determining the amount of compensation in terms of section 50 within bracket 2 of the LA Act.
that's
That will wrap up everything.
otherwise they will
No,
again
no,
go back to the
yeah.
Supreme Court and say that see that we have not been given opportunity.
এটা add হয়ে যাবে।
একটা সিওটি আছে একটা আরেকটা appeal আছে।
What are all disposed of?
Previously disposal. No, those are pending.
These are, I said no.
Court and what else is there? One court is there.
One more appeal was taken.
One is
বাকিগুলো ওই নাম্বারগুলো দিয়ে are disposed of consequential in terms of the above judgment.
আরেকটা court কে file করেছে?
Another appeal has been filed by the state. Yes.
Probably court has been renumbered. This court is still appearing. Now the appeal is of the state government that I
We are
just
putting it as stand disposed of because
Stand.
otherwise it will be reflected in the CIS system as pending.
stand disposed of.
Madam, it is staple করে রেখে দেবেন।
Grateful.
Thank you. Yes.
This was my appeal.
Yes.
It was my lord's direction that either we settle or
It has already been at last.
settled. Yes, we have settled on the terms that that they will pay a sum of rupees 44 lakhs and odd. 46 lakhs and odd.
Can a short application be filed?
It is they have accepted, and we have also given a letter to that effect.
That letter, may be kept on record and appeal may be disposed of.
And the only thing is that they have to pay this amount within 21 days. Otherwise,
We'll make it a part of the decree.
30 দিন করা যাবে আমি জিজ্ঞেস করছিলাম
Makes it.
my lord
হ্যাঁ,
make
30
it
দিন।
30 days my lord
Very
I
good.
have but একটা কপি my lord কে দিন
If your lordship desires, we can put it as an application.
আমি ছেড়ে
But,
দিই case
I was thinking that would bind both of you. That would bind
Can
both
do
of you.
that, my lord.
Do a file a one-page application. Mr. Mukherjee will, whenever you say just file it and have it mentioned, Mr. Should just mention it.
But
Tell us that
I'll
the
do,
appeal is on
I'll,
20.
I'll do that. Not, but my learned friend takes note that
We'll
this
take
is
this on record. We'll record whatever you are saying.
lordship.
We'll record that.
and my lord
And-
one thing my lord I am just talking but make it 30 days my lord not 21 my lord I had to talk with my learned friend make it 30 days
And my lord, till the PM lord, the interim order that your lordship has not passed, that will continue.
But
that
appeal
is
may be-
not,
if
lord.
the appeal is disposed of my lord by the settlement my lord
I-
everything is
No, that doesn't
Don't
mean
pay,
that
then
if
what
you don't pay, then I have to come and again revive the appeal and
Then what happens?
and as well you know, so make a condition that as and when matter will be payment is made the entire appeal is
you pay
treated as
within 30 days and up to the date of payment, the interim order will continue whenever you.
Interim order.
Not
not
to
to-
create
not to
any third party
third party interest.
That your lordship will
Very well.
find in my lord's order dated.
Then we are doing it right now. Why?
yes as your lordship as your lordship
Learned senior counsel appearing for the appellant as well as learned counsel
Maybe
appearing
just
for
a-
the WBSI DCL hand over copies of
So দিয়েছি, আমারটা দিয়েছি আমি, আমারটা দিয়েছি
a communication by the WBSI DCL
no by the
by the appellant. No, by the
appellant my lord this is the appellant
Yes, by the appellant to the managing director of the WBSI DCL recording the terms of settlement mutually arrived at by the parties. Push up as per the same comma compensation of rupees 46,04,000 has been offered by the WBSIDCL to the appellant as a condition for disposal
for both my lord for both masonry and building
for disposal of the appeal. Push up next para. The said compensation is divided under two subheads, comma being rupees 4,44,000 towards the machinery lying at the premises and rupees 41,60,000 towards the value of the three-storied building standing thereon. Push up next para. Although in the letter, comma, the time for payment of the amount has been stipulated as 21 days from the date of communication of the letter, comma, learned counsel appearing for the WBSIDCL, comma, on instruction submits that 30 days
from my lord
from
today
this date
from this date
be given to the WBSIDCL, to which learned senior counsel for appearing for the appellant, comma, on instruction agrees in principle. Full stop. Next para, in view of the aforesaid settlement arrived at by the parties, comma, MAT 281 of 2022
can 1 or can 2 চৌধুরী থেকে ঠিক আছে
along with can 1 of 2022 and can 2 and can 2 of 2026 are disposed of in terms of the letter dated August 21, 2026, which is handed over today and be made a part of the records. Push up next para. The interim order granted earlier
on 6/1/2026
on January 6, 2026, comma, restraining the respondents from selling, transferring,
Lord, it shall not deal with the subject plot in favor of third parties.
restraining the respondents from dealing with the subject plot in favor of third parties shall continue till the payment of rupees 46,04,000 in terms of the agreement arrived at between the parties and shall stand automatically vacated upon such payment being made by the WBSIDCL to the appellant. First up, next para. Subject to such payment, comma, the parties shall not have any further claim against each other insofar as the subject matter of the present appeal is concerned.
as
Great.
grateful to you
Orders to cost, sir.
I'm good
একটা নেবে
Ultimately, my lord, I couldn't come on the last two occasions because my illness, my lord.
Oh, that's yes, time was short.
Yeah, that because I was suffering from chest congestion, my lord, I couldn't come.
How are you now?
But that's
Now, a part of the chest congestion is now
The major congestion.
the major congestion is now.
Much
Thank you.
Great.
Thanks.
In this matter, Mr. Holocaust is appearing for the response.
Yes, he was sitting here. We saw
And
him.
he was, one matter is colon and he has went to.
You are there, you said.
My lord,
Who is for the appellant?
my lord, he's there.
No. I'm for the erstwhile advocate against whom some allegation is.
Let her come. She's appearing. She's the respondent one in person.
No, sir.
Who is the appellant then?
My lord, Mr. Indrajit Bhattacharya is appearing for the appellant, my lord.
We gave a last chance to you on the last occasion. You also asked for adjournment.
As per instruction, my lord, we have received the change brief today, my lord. I'm
No,
praying for
we dismiss the appeal for default.
my lord, upon instruction, I'm submitting for your
No,
lordship that
we gave you a last chance. We gave you a last chance. We're dismissing for default. If there is any interim order, that will be vacated. Come and file a discussion, then we'll consider.
The allegations against me, lordship, I would like to point to highlight because this is something where the advocates, they have been casted allegation against the advocate. Erstwhile advocates, nothing is there, lordship. I can show you from the document which I am carrying. If you see their application section 5, 4 to 5 paragraphs have been mentioned there that the erstwhile advocate had not done this work. They have not.
Then we'll keep it pending. We'll give you a one week. Please come back next week. Next Thursday. Again, dismissal for default, that would not serve any purpose.
And this will continue. This
Yes. If there are, yes, we remember now. Very well. We are putting it next Thursday. No difficulty for anyone. If you are in, even if you are in difficulty, you have to do the matter. You come prepared. If your senior is not there.
Sure.
What is your name?
Shubhayan Barik, my lord.
Mr. Barik, you have to come prepared if he is not. Who is your senior?
Indrajit Bhattacharya.
You have to prepare yourself and move the matter. Make it clear to Mr. Bhattacharya also. An adjournment is sought on the ground that a new set of counsel are appearing for the appellants on change. First of next para, we note from our order dated August 11, 2026 that due to non-appearance of the appellants at the time of call, a last chance was given to the appellants to move the condonation application. First of it was further recorded that in the event the appellants are not represented on the returnable date within bracket today, bracket close, appropriate orders may be passed ex parte in the absence of the appellants. The next para, however, keeping in view the predicament of the appellants, we give a final chance to the appellants to move the condonation application on the returnable date. First up, however, no further chance will be granted to the appellants. First up, let the matter be listed next under the same heading on September 1, 2026. Yes, 1st September 2026. Next Tuesday, not Thursday. We said Thursday, Tuesday. Yes. And he was there in the morning also. So he has a right to have his name recorded. Yes.
I appear for the respondent, writ petitioner, respondent number 8, my lord. My lord, the matter perhaps has become infructuous, my lord, because the direction was, my lord, kindly takes up the memo, my lord, to give an opportunity of hearing and decide, kindly comes to paragraph 15, my lord, of the memorandum, my lord. Page 11, internal page 11, paragraph 15, my lord. Therefore, the purpose of justice would be served if the subdivisional officer such and such is directed to take appropriate steps against the private respondent number 8 to 10, affording after affording opportunity of hearing to them as well as.
One second. Yes, please continue.
My lord, yes.
After affording proper opportunity
of hearing, my lord, opportunity of hearing to them as well as necessary parties strictly in accordance with law within 8 weeks from the date of communication of this judgment and order, keeping in mind the pendency of the title suit in view of the notices dated such and such issued under West Bengal Public Land Eviction of Unauthorized Occupancy Act 1962, so that illegal construction made in Jola and Doba land comprising of Dag number such and such belongs to irrigation department shall be removed and demolished. Accordingly, my lord, notice was given.
You are the complainant.
Yes, my lord. My lord, I had filed the writ petition, my lord. Accordingly, the opportunity of hearing was given, and subsequently the place was demolished, and my lord,
Demolished also.
No, my lord, he is living in this matter.
Yes, we saw him. He remember also he leading.
My lord, opportunity. Oh, I forgot to place the opportunity of hearing part. It complies with what's পাগল ভুলিয়ে গেছে।
Paragraph 15 এই direction ছিল।
Have I handed over dated 24th of
June?
হ্যাঁ,
Right one or some other thing?
No, no, no.
Private letter.
No, 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 no. Well,
complaints report আছে পরে।
opportunity of hearing এটা একটু কোথায় ছিল?
আমি অফিসে বসে।
একটু বলবি।
দেখি।
May I hand over that opportunity of hearing thing? Well, over hearing also given order sheet passed accordingly. Well, kindly sees. Accordingly, in the middle, in compliance with the order, a notice was served to all the private respondent, petitioner, and the other concerned to attend the meeting and attend the hearing at the office chamber of SDO such and such on 10/2/2025. All the petitioners, private section officers.
This matter was passed of November 2022. What is order was only contract. Thereafter pursuant to such order, the unauthorized office director interposes DVP it is unusual. It has been deposited এটা হয়েছে according according to
None appears for the appellant at the time of call. The read petitioner respondent number 8 is present through land counsel. Stop. Next paragraph. It appears from record that in paragraph 15 of the judgment and order impugned dated 27th November 2024, the learned single judge was pleased to record as under paragraph 15 to quote.
মেমোতে পেয়ে যাবে কপি থেকে নিয়ে নিয়ে সার্টিফিকেট কপি পেয়ে যাবে।
The learned next paragraph. The learned counsel for the read petitioner respondent number 8 handed over a copy of the order sheet containing a reasoned order passed by the subdivisional officer, Etamogra Irrigation Subdivision, Etamogra, Purbo Medinipur, dated April 8, 2026, wherein an opportunity of hearing was afforded to the parties. And pursuant thereto, a reasoned order was passed. Stop. Next paragraph. The learned counsel for the read petitioner stroke respondent number 8 further handed over a copy of the compliance report issued by the subdivisional officer, Etamogra Irrigation Subdivision, on June 24, 2026,
wherefrom it appears that pursuant to the order dated April 8, 2026, the unauthorized structure erected on the said government land were removed and the possession of the land has been restored to the government. Stop. After eviction, proper demarcation of the plot was done and government signboard has been installed at the site to prevent future encroachment. Stop. Next paragraph. The learned counsel for the writ petitioner stroke respond number 8 submitted that in view of the aforesaid fact situation, the appeal has become infructuous. Next paragraph. In the circumstances, considering the materials on record, the appeal being MAT 278 of 2025 with the connected applications are dismissed as infructuous. No order as to cost. The interim order, if any, stands vacated. The letters and orders submitted before this court today by the writ petitioner stroke respond number 8 be kept on record.
Lordship, and for the appellant, I'm led by my senior, Mr. Kaushik Gupta. Being unwell, he couldn't come to court today.
Who?
I'm praying for some time. Mr. Kaushik Gupta.
Miss Sen was also there. Miss Jhuma Sen is also.
She also couldn't come.
You have come, you move the matter. You are Ospita there?
Yes.
Move the matter. Your name is also there. What is the matter about? Start the matter.
Lord, I'm
I do
appealing for
not-
the state.
Yes. You have been there all along. They were also there on the previous occasion.
Lord,
Start
I'm
the
appealing
matter.
the first time. I am appealing first time. It has just been allotted.
Some other. Oh, some other. Yes.
Lordship, I do not have the brief as of now.
Don't say that
I
to
could
the court.
come with the
Prepared
instruction.
will give you 10 minutes. How long are you practicing?
I just got my enrollment last year.
Last?
This 2026
Which month?
July.
July.
Like 2025 batch.
Fine. Get yourself prepared. We'll give you 10 minutes time.
Your Lordship, if I could get some instruction and come back tomorrow.
No instructions. Start the matter. We'll give you 10-15 minutes time. You prepare yourself. You please stay back a bit. 15 minutes.
I will.
For the future of the bar, stay back. Yes. You get 15 minutes, ma'am. Sit somewhere nearby so that we have access to the file and start reading. Go there and read. Read your prayer portion. Your learned seniors are there. They'll help you.
If I could just say one thing, I was not in this matter from
You
the
are now in
beginning.
this matter. Go and sit and study the matter.
All right.
Quick. Don't have the entire day. We'll give you 15 minutes only. Yes. Pass over. Next matter. Yes.
Lord, item number 10 to 11, 15, analogous matter.
Achha, 10 to 15 action dekhi.
Analogous matter.
Right.
And Lord, I understand the matters are assigned matters. The background of the case is required to be placed before a lordship. The original notification was issued by the District Magistrate Burdwan imposing restriction regarding flying of vehicles inside Burdwan town from different terminal point, excluding the school buses and town service buses. That notification was challenged before this court, and your lordships, while sitting singly,
Yes.
has been upheld the notification, upheld the said notification.
Take up this matter.
But it strikes in my mind, although it is assigned.
You are right. You are right. You should
And,
not.
and in that matter went to the appeal bench up to the apex court. Your lordship's order upholding the notification was upheld.
Right.
In the second round of litigation, there is an exception clause carved out in paragraph 9 of the said notification, based on which the second round of litigation has been started. And the petitioners before lordships exclusively covered under the exclusion clause at par with the town service buses who have been allowed to ply their vehicles from the outskirts of outskirt of two established bus stand, Namabhat bus stand and Alisa bus stand. And based on which the second round of litigation, the order has been passed by the Honorable Honorable Justice Rai Chattopadhyay, against which these appeals have been favored.
Is the order which I passed, is that even remotely challenged by any of the parties here in this matter, or that has attained finality?
Finality. And second round of litigation, the exception carved out in the paragraph 9 of the said notification was assailed. Based on which several applications were filed, wherein order has been passed, and that order has been challenged under the different writ petitions, and against the order, these appeals have been arises. It strikes in my mind, once the original notification was heard by your lordship, should it may not be.
We'll make a request to the Chief Justice assign this.
Although it is an assigned matter, I think inadvertently it has been assigned. I understand.
No, but we don't know what logic was. Maybe because there was some order at some point of time. Maybe that is the reason for assigning also. We don't know, but we would feel embarrassed in taking up the matter.
Yes, well, I feel it.
Absolutely. Thank you.
And Lord, out of 6 matters, 3 belongs to me and 3 belongs to Mr. Dilip Samanto. Now he has been admitted.
Yes.
He has been admitted in the hospital because of
Mr. Samanto?
Dilip Kumar Samanto.
Mr. Dilip Samanto, yes. He does this transport matters also.
Yes,
he moved in in that matter also he appeared.
Yes, along with me.
Yes, you are there. I do.
And my lord, out of 6 matters, 3 matters belongs to him and 3 matters belongs to mine. And therefore,
all the matters involve the same issue.
Same issue, same order. Bunch of writ petitions were heard by his lordship, and one order has been passed covering all the matters.
10 to 15 টা একটা common order করে and identical issues are involved in all the present appeals. Full stop. Learned counsel appearing for the appellant in some of the matters points out that the scope of the challenge in the present matters is an exception clause carved out in a notification which had previously come up before this court. Full stop. In the said round of litigation, one of us, bracket amar puro namta dao, had disposed of a bunch of writ petitions upholding the validity and virus of the notification. Full stop. Subsequently, a challenge was preferred before a division bench of this court, which went ultimately up to the Honorable Supreme Court. Full stop. The notification was affirmed up to the Honorable Apex Court. Full stop. Next para. However, since the present dispute pertains to an exception clause in the self-same notification, which was upheld by one of us as indicated above, for the sake of judicial propriety, we are of the opinion that it would be inappropriate for us to decide the present appeals. Full stop. Next para. Accordingly, let the matters go out of the list with a request to the Honorable the Chief Justice to assign the matters before some other bench where one of us, within bracket amar puro namta, is not a party. Full stop. The parties will be at liberty to approach the Honorable the Chief Justice for such purpose. Honorable Acting Chief Justice.
No, after release, it will be automatically assigned in the present system.
This order will be, this files will go to directly.
Although I was eager to argue the matter before Lordship, but without disclosing the background of the case, I don't want to place the case. I feel it.
You have total faith in counsel.
No, I feel it that without disclosing the background, I should not open the case.
Rightly so. It would be an embarrassment after 2 days of hearing.
Yes. Now, I feel it that possibly your Lordship should not take up the matter.
Thank you very much. Thank you.
But in the second round of litigation, there is a very interesting point. The exception clause has been carved out, which is very interesting, which strikes us later on.
When a different bench passes the judgment, we'll see it in the
when initially entire notification was under challenge. Subsequently, it was rejected. One exception clause.
Directly, the previous judgment which I passed will directly come into play.
Yes, yes.
That will be cited and
Yes,
that will
yes,
be
yes,
distinguished.
yes,
So,
yes. Yes. Okay.
thank you. Yes,
My lord, we have the petitioner.
yes, appellants. You are also appearing on the last time, right?
Yes. My lord, we have completed all the.
You have to serve a notice on the other side.
We have completed that.
What is the notice? No, we requested you to give a notice along with a copy of the pleadings indicating that the matter shall next be listed under the same heading.
Yes, my lord.
What is the receipt of that notice?
Our senior advocate Vikas Ranjan Bhattacharya, he is not unable to appear today. That is why we are praying for adjournment.
You are there. You start the matter.
I can't, sir. He is a senior member.
You are also a senior member. You start the matter.
No, sir.
We are forcing the lady to start. She has joined profession 2 months and you will not start. Start the matter. First file the notice, please. Receipt of the notice.
Yes, I have served notice.
No, you have served on the advocate for the private respondent. For the private respondent. What about service on the state?
No.
We directed to serve on the state. Within bracket, it's written for the private respondent. No, we asked you to serve on the state. An adjournment is sought on behalf of the appellants on the ground of ailment of lead counsel. So, sub next para, a receipt is filed today from which he finds that a notice of the pendency of the matter has been served on the learned advocate for the private respondent. However, by your order dated August 4, 2026, we had specifically directed the learned advocate and record for the appellants to serve a notice along with copy of the pleadings to the state respondents indicating that the matter shall next be listed on August 11, 2026. Since we do not find any such notice, the learned advocate and record for the appellants is requested to serve such a notice, along with copies of the pleadings on the office of the learned government pleader, indicating the pendency of the matter in our list, and file a receipt in that regard on the returnable date. Let the matter be listed next on September 1, 2026.
My lord, we have served also affidavit.
Why did you suppress this so long? We passed an order. You could not have filed this. You have served already on the government pleader.
Yes.
Order you pay 20 rupees to our staff while you go out for tea. That is a cost imposed on. An affidavit of service indicating service of notice on the office of the learned government pleader, as well as a receipt of service of notice on the learned advocate for the private respondent, are filed today and are kept on record. On the prayer of learned counsel for the appellants,
Lordship, I am appearing for the state. Lordship.
the matter is adjourned till September 1, 2026. It is made clear that no further adjournment shall be granted to the appellants on the returnable date. Sir, you please come prepared. You are Mr. Mondal?
No.
You are Mr.
Ronis Gotagudat.
You are Ronis. You appeared on the last occasion.
No. I am appearing for the petitioner.
What is your name?
My name is Pulin Chandra Maiti.
Well, Mr. Maiti, please come prepared on the next day if you are
1st of September. 1st September.
1st September. একটা ডেকে নাও, ডেকে নিয়ে তারপর পাস হোক। Where is the appellant? You are for the respondent number 1. You have been consistently appearing.
Yes, my lord.
You have to serve a notice.
Yes, my lord.
File that.
My lord, a notice was also served.
This I am representing.
My lord, I am for the respondent number 2.
He served notice and LR also informed someone, Mr. Vishwajit.
Dismiss for default. What can be done? What is the setting for the appeal?
My lord, my senior is on VC man. Shankanath Mukherjee. Hey.
Office of the How did you get this?
By post, my lord.
Oh, acha.
Mr. Akhtar has received.
I am for opposite party number 2. Respondent number 2 in appeal.
And notice served on the office of the but there is no receipt by the legal remembrancer. Mr. Samanta has signed.
Then you know, send the letter. Right. Mr. Samim Akhtar, hearing for the respondent number 2.
The 29 June letter where I will serve to the government leader.
You have not served. Samim Akhtar. Mr. Samim Akhtar is appearing for whom? He cannot appear for the state. Learned counsel appearing for the respondent numbers 1 and 2 hand over the receipt in respect of service. Sorry, respondent 1 and 2. No, respondent 1 hands over a notice with regard to service of notice.
He served the notice.
Oh, acha, acha. You served this notice?
Yes.
Former respondent notice. Respondent.
We directed the respondent number 1 to serve a notice on the state appellants. By your order dated August 4, 2026, we had requested the learned advocate for the writ petitioner stroke respondent 1 to serve a notice about the returnable date on the state appellants. Although notice is handed over in court today, we do not find satisfactory service having been effected on the state stroke appellants. Apart from that, a communication from the office of the legal remembrancer allocating the matter to a learned advocate for the state is also handed over. Both the said documents be kept on record. However, since we are not satisfied that proper service of notice of the pendency of the appeal before this court has been served, we direct the learned advocate for the advocate on record for the petitioners respondent 1 to serve a notice to the office of the learned government pleader indicating about the subsistence of the matter, further intimating that the matter shall next be listed on September 1, 2026 under the same heading, and file a receipt in that regard, receipt stroke affidavit of service in that regard on the returnable date. You serve, yes. Now you have directed. Previously we requested, you did not serve. Now you are directing. Ask your junior to draft it and ask your clerk to serve immediately. Yes, yes. We will take it up on next Tuesday. এই হেডিংটা দেখেন, হ্যাঁ আর কটা আছে হেডিং দেখেন দেখেন তো নেই দেখেন অ্যাকুরেটলি
My lord, with regard to item number 18, it is with regard to registration of e-rickshaws. Now, during pendency of the appeal, original writ petition has been disposed of on 21st
this
August.
was against ad interim order.
Lordship, this was against order of directing exchange of affidavits.
That has been challenged. You are for the appellant.
I am for the appellant.
We are dismissing not only as infractuous but with costs.
Original writ petition has been disposed of, my lord.
That does not save you. Why did you file this appeal in the first place? Direction of affidavits?
Because, Lordship,
Wait.
there was similar.
Since you are for the appellant.
I am for the appellant, Lordship.
Lord
There was
Counsel-
similar orders.
Lord Counsel for the appellant submits that both the appeals have become infractuous.
No, first has been disposed of. Second is yet to be disposed of, Lordship. It has
MAT 10 of 2026?
Lordship, first,
Advocate undercourt in both is Sanjeev Datta.
Lordship.
Reflected in.
First matter has been disposed of. Item
So 19 then you argue the matter. 19.
19 is yet to be taken up by the single bench, Lordship.
So move the appeal so that you can dismiss it right now. That also you have challenged an affidavit direction.
Lordship.
Achha, Learned Counsel for the appellant submits that MAT 9 of 2026 has been rendered infractuous in view of the main writ petition, comma, against an interim order passed in which the present appeal has been preferred, comma, has since been disposed of. Full stop. Accordingly, MAT 9 of 2026 is dismissed. MAT 9 of 2026 along with Can 1 of 2026 are dismissed as infractuous without an order to cost. Yes, what is MAT 10?
And Lordship, so far MAT 10 is concerned.
Yes. You are appearing.
On intelligence matter, I said, sir, supply the copy of the all the documents to the government.
Do that. That will be better.
That idea.
Yes, that was a previous direction. Yes. What about MAT 10?
So far, MAT 10, may I be prayed for not this week, Lord?
You may pray. We permit you to pray, but we are refusing that prayer. Come to the input.
Now I shall.
Affidavits are directed. Why have you preferred the appeal? You asked for interim relief.
Lordship, kindly come page 208 of my CAN application, volume 2, my lord.
What was your grievance in the writ petition? Certificate of registration was not issued.
Lordship. And there was several.
What sort of interim order you prayed?
Interim order prayed with regard to registration, allowing registration of my vehicle. I am the manufacturer. I manufactured e-rickshaw, prototype approved, Lordship. Similar orders have been passed. At least 200 similar orders in identical matters have been passed.
What is the wrong in the impugned order? Impugned order only directed you to file the respondents to file their affidavits in opposition.
Lordship.
So why have you challenged this? What is the merit of this appeal?
Because, Lordship, under the similar circumstances, similar order.
What is the interim order prayed for by you before the writ court? Similar circumstances, what has been done? Writ petitions have been allowed.
Lordship.
So then the writ petition will be hard on its merits. You have challenged an interim order whereby affidavits were directed. What is the wrong in this order?
Lordship, in earlier matters, there was no direction for filing affidavits. On the basis that I will be.
That's why, is that a
Lordship, I am prototype approved.
No, this is a ratio decidendi that no affidavits will be directed. What sort of dismiss this appeal with costs?
Lordship,
unnecessary appeal, wastage of court's time, wrong bench to be assigned for you.
Lordship, kindly come page 208 once, Lordship.
208. Previous matters, the orders might have been passed.
In 200, only in my case.
Affidavit direction is not an appealable order at all under the latest patent.
But Lordship, under clause 15, letters patents with deepest.
It has to be a judgment.
Lordship.
With or without the deepest respect.
But
It has to be a judgment.
what is my
Judgment, what does judgment mean? Some rights have to be decided.
Lordship?
What right has been decided?
Nothing. But I will say under the clause 15 letter patent, Lordship, it is with regard to civil suits, with regard to I don't think it is with regard to article 226.
Acha. This is an appeal under article 226. So what is the merit in the appeal?
Because similar order has not been passed in my favor. Earlier writ petitions was disposed of in motion case on the same subject.
The present challenge has been filed against an order whereby the learned single judge directed affidavits to be exchanged.
And Lordship,
in connection with the writ petition. For sub next para, we find from the impugned order that the learned single judge recorded that the subject matter of the writ petition is with regard to non-issuance of certificate of registration to e-rickshaw vehicles manufactured by the writ petitioner on the ground of an order of injunction being passed by the learned additional district judge, 13th court at Alipur, dated February 24, 2020, in title suit number 27 of 2018, regarding registration of battery-operated eco-friendly e-rickshaws. Whose of next para, however, from the impugned order, we find that the learned single judge has merely directed affidavits to be exchanged between the parties and has not substantially decided any rights of the parties. Full stop. That is the impugned order.
Lordship, kindly come, impugned order page 3. Same court has disposed of similar type of matters, Lordship. Only in my case, opposition has been directed. Lordship, kindly come page 3 of the impugned order.
Yes.
Kindly. Next court on the same issue has already taken a view in the order dated such and such, which is reproduced below. In view of order passed by Honorable Division Bench, there is no restriction of the e-rickshaw vehicle, provided the vehicle are different and distinct from the category forming subject matter of title.
Push up next para. Learned counsel for the
Honorable Court has disposed of earlier matter.
Learned counsel for the writ petitioner stroke appellant argues that from the impugned order itself, it will be evident that the self-same bench which passed the impugned order had previously disposed of writ petitions of similar nature at the outset, without directing any affidavits to be exchanged, on merits. Full stop. Next para. Accordingly, it is submitted that the learned single judge ought to have decided the writ petition itself on the day when the same was moved, since the state was also represented by counsel. So next para, however, we do not find any right of the parties being decided by the impugned order. So accordingly, there is no scope of interference within the limited scope of an intra-court appeal. By the impugned order, the learned single judge, on the prayer of the state, merely directed affidavits to be filed. In any event, the time stipulated for filing such affidavits has already expired. Accordingly,
no affidavit have been used.
We are apprised that no affidavit has been filed as yet. No. Be that as it may, it is for the learned single judge to dispose of the writ petition itself. No interference is called for in the present appeal. Accordingly, MAT 09 of 2026 along with CAN 1 of 2026 are dismissed, thereby affirming the impugned order dated December 18, 2025, passed in WPA 25289 of 2025, with a request to the learned single judge to consider early disposal of the writ petition itself on merits. Next para, we make it clear that the merits of the writ petition have not been gone into by this court. Thank you.
I'm good.
Next. ওটা 10 হবে, ওটা 9টা কি হলো? আপনি 9টাই দিয়ে দিয়েছেন। Anyway, 10 করে দাও।
Lordship, may I pray for the time?
আগেরটা তাহলে অন্য নাম্বার হবে, উল্টো নাম্বার হবে। আগেরটা 9ই বলেছিলাম, আগেরটা 9, এটা 10। নেক্সট, এরপরে আবার পাসওয়ার্ডটা ডাকবো। ইয়েস,
For the municipality, your lordship, in this matter, respondent.
we find from the order dated August 4, 2026 that the matter was adjourned on the said date on the prayer of the appellant. Full stop. Today, at the time of call, none appears for the appellant. Although the respondent of municipality,
Yes, sir.
which
Mahesthala municipality, your lordship.
Pardon?
Mahesthala municipality, your lordship.
Although the respondent of Mahesthala municipality is represented through council. Full stop. Next para, as a last chance to the appellant to argue the matter, the same is adjourned till September 1, 2026. Ever password. Yes, what is the matter about?
The matter APDR, which is Association for Democratic Rights, had applied for a stall in a book fair. That is the 48th edition of the International Kolkata Book Fair last year, which was refused by the respondent number 3, Publisher and Bookseller Guild. Now, challenging that,
For the
APDR.
state.
Now, challenging that, APDR had filed a writ petition being WPA 587 of 2025. The same was dismissed by Honorable Single Judge as non-maintainable. Now, challenging that, an appeal has been filed before your lordship.
Not maintainable because Booksellers Guild is not state.
Yes.
What's your answer to that? We are thinking in the same line.
No, the learned single bench had said that had stated that because the booksellers claimed that our APDR was not a part of the listing since it's not state, so we cannot include them in this book fair.
So it's very popular, the book fair, everybody knows the
Right.
book fair,
And
but it's a public event. It was held not to be a public event organized by the state. This is not for any public purpose. The guild is an association of the various booksellers.
Right.
They're a private body.
Yes.
They organize this. So rightly held to be not maintainable. Why should you interfere with this?
But the APDR has previously always entered in this, participated in this book fair, and all of a
That
sudden,
is your cause of action. We are on the maintainability. Whether a writ petition lies at all against the booksellers guild.
here the question is whether the writ petition can be issued against a private body, even if
What
they.
is your answer to that question? You know the question.
Yeah.
What is the answer to the question?
The answer is yes, it can be issued. A writ can be issued against a private body, even if they are performing a public function. But I would like to request you if I could come up with judgments.
You are Miss They.
Yes.
You are also appearing in the matter.
No, my lord.
Very well. Helping your friend. Then you are not recording your name.
No, my lord.
Very well. Although Ms. Oshmita De, learned counsel for the appellants, don't give the name of his seniors today.
No.
Ms. Oshmita De, appearing for the appellants, commences argument, in order to furnish further clarification required by the court, the matter is adjourned till September 1, 2026 for arguments on merits. Come back on that.
Grateful, your lord.
Thank you. Thank you for starting. So, if you can submit that much, you can also come prepared with the judgments and assist your senior on the next day.
I will sure.
And we'll insist that you start the matter on the
You have
next.
supplied 11 judgments to me, a list.
11.
Actually, more than that, we'll
11 judges
get.
there.
We'll insist then we'll insist that you argue, not your seniors. Yes, next.
Yes.
Thank you.
Lordship, I appear for the appellants.
Here for the respondents.
State of West Bengal is the
State, you are for the state.
I am for the state, Your Lordship.
Yes. What is the matter?
Lordship, learned AGP is leading me in this matter. I was praying for not today.
No. You start the matter. What is the matter about?
Lordship, this is a matter. There was a proceeding under the Land Reforms Act, and the said proceeding was started in 1994, which was challenged before this court in this writ proceeding. And by an order, Your Lordship comes at page 55 of the. There's the order in the writ proceeding. And the ordering portion is page 59.
Yes.
Page 60, Lordship. So as the aspect of matter is being considered by a division bench in pursuant so and so, I am of the opinion that the concerned respondent had passed the appropriate order in terms of the aforementioned judgment. So the state was directed to pass the orders in terms of the judgment as noted above. Subsequently, there was a proceeding before the LRTT, and by an order at page, if Your Lordship comes to page 75.
At that point of time, it was also observed that if any final order in the aforementioned proceeding has been passed, the same shall stand.
That should be set aside. But there was no final order.
There was no final order.
No final order.
Well. Yes.
So then, learned LRTT, there was a proceeding before learned LRTT.
Yes.
If Your Lordship comes at page 75, the ordering portion, para 6.3.
Yes.
In view of the aforementioned order dated 10/12/96 passed by the Honorable Court in CO number so and so, which I had placed earlier, the order passed by Revenue Officer in vesting proceeding in so and so is quashed.
That was the final order.
That was the final order, and it was directed to comply with the order of High Court and take all consequential actions.
All right. Yes.
Now, in compliance that we have taken the order has been passed in 2011. Now they have filed a contempt proceeding before the LRTT, which is at page 1117, Lordship. This is the impugned order before a Lordship. In the impugned order, in the contempt proceeding, they have gone and passed they have quashed the order passed in 2011, which is not permissible in contempt. They cannot, there is no contempt as though we have not taken. This is a separate cause of action. The order has already been passed in terms of the Honorable High Court.
Yes, what do you say, Mr. Mundu?
They did not prefer any appeal.
Use the microphone, he can't hear.
Against the.
Please help.
But they did not prefer any appeal against the judgment of the Honorable Single Bench of this Honorable High Court.
In a contempt proceeding, can this be done? Tell us this.
One thing, my lord, in a contempt proceeding,
yes,
only to comply with the order of the Honorable High Court, and subsequently the members of the tribunal also passed same order that you please comply with the order of the Honorable High Court.
But here, proceedings initiated.
But they, my lord, what they have
perverse,
done,
bad, and untenable.
when we, my lord, we filed an application for representation for to prepare record of rights or
We can't use the microphone.
My lord, they long thereafter, my lord, they challenged it, but they appeared in a contempt proceeding. They appeared. They appeared, and when the tribunal asked them to comply with the order, they come up with the report that they have initiated a proceeding afresh. We submitted that this proceeding itself is contemptuous, because they did not prefer any appeal challenging the order of the Honorable High Court, nor the order of the tribunal. Therefore, they are bound to comply with the order. And Lord,
bound to comply with the order means what would they have to do to comply with the order?
If your Lordship kindly have a look to the order of the Honorable High Court in a single bench, Lord, court quashed the order.
Yes.
Vesting order quashed.
Final order was quashed.
Final order was quashed. There was no further proceeding for vesting. They initiated when?
They initiated a fresh proceeding for vesting.
When? After passing the order by the contempt in a contempt proceeding. Long thereafter, years together.
They initiated a fresh proceeding.
They wasted decades together.
They initiated a fresh proceeding.
Fresh proceeding.
How can you quash that in contempt proceeding?
No,
It's a fresh cause of action.
we did not
Challenge
prefer
that.
quashing. We did not.
We will set aside this portion of the order.
Yes, sir.
Tribunal set aside that order.
Wrongly, going beyond contempt jurisdiction. That is what your learned friend also submits.
But whenever they think that they will proceed with the
whenever they think that they will do a wrong, you go and protest, object, file a proper challenge against that proceeding. Let it be quashed. Some class will quash it probably.
Already 2-3 decades have been passed away, my lord.
So all these are relating to Mr. Mundal, the propriety of the second proceeding. We are looking at a contempt of an earlier order.
When they did not prefer any appeal against the order of the Honorable High Court.
They have to comply. Compliance means what? The order of the High Court was that that order is quashed.
Quashed.
That order has been quashed.
Whenever they think that they will proceed, they will start proceeding. I'm asking myself.
Going round and round. Mr. Mundal, we are not validating any subsequent action. We are just saying that whenever they like, they may start a wrong action. Your remedy does not lie in a contempt from an earlier order. Earlier order, the order was directed to be quashed, that has been quashed.
That has been quashed.
New contempt proceeding is a fresh proceeding. The maintainability of that you are entitled to challenge. You are entitled to, you know your remedies better than us, Mr. Mundal. You can have it quashed in a 226. Go and, or before the tribunal even. You can challenge that proceeding before the tribunal and have it quashed. But it's a fresh cause of action. How could the tribunal say this in contempt?
They produced this as a report. We find from the report.
No, this is overaction of the tribunal. Mr.
They produced report, my lord. In the report, they disclosed they have proceeded with the matter, and fresh vesting proceeding order of vesting was passed. My lord, kindly have a look to page 55.
This is a bit going beyond jurisdiction, Mr. It's a question of maintainability of the fresh application. It's not a contempt per se. If there is a scope of interpretation, Mr. Mundal, then it is not contempt. Previous proceeding was vested. Obviously, a new proceeding on the self-same cause of action is not maintainable. Even we may say that it's not contumacious directly.
But they must proceed.
Restraint order from initiating a fresh proceeding.
If they want to proceed, they should initiate within a reasonable period, my lord.
Yes. If they don't, then what happens? The contempt court will say that I'll quash that. We don't understand this logic of yours.
Contempt
Two are separate things.
Only to comply with the order. That's much was
compliance with the order was quashing the order. Order stands quashed. What else were they required to comply? They were not directed to do anything. This court had held on the last occasion, in view of the aforementioned order such and such, the order passed by the revenue officer stands quashed.
And we were directed to pass another order, Lordship.
Comply with orders of the Honorable High Court and take all consequential actions. Now, they have taken some consequential action. Whether that consequential action is good in law, bad in law, Mr. Mundal, that's a subject matter of legal arguments. Contempt court cannot do this. The present appeal arises against the present writ petition arises against an order whereby, sitting in contempt jurisdiction, the learned tribunal directed a fresh proceedings initiated by the BL and LRO, Kharagpur Roman 2 under sections 14 capital T bracket 5 and 14 capital T bracket 6 were held to be perverse, bad and untenable in law and were quashed and set aside. Next para. Learned counsel for the appellant stroke state points out that initially, writ petition. Writ petitioner points out that initially a learned single judge of this court had passed an order in CO number 842 within bracket W of 1995, on December 10, 1996, disposing of the writ petition with the observation that in view of the division bench judgment in Poschim Bongo Bhumijibi Krishak Samiti and others, versus State of West Bengal, comma, reported in 1996 WBLR 242, comma, the concerned respondents should pass an appropriate order in terms of the said judgment, and that if any final order in the aforementioned proceeding had already been passed, comma, the same should stand quashed. Full stop. Next para. Subsequently, comma, the matter came before the Land Reforms and Tenancy Tribunal,
Sorry, my lord.
which, comma, by its judgment and order dated June 8, 2007, comma, acting in terms of the order dated December 10, 1996, passed in CO 842 bracket W of 1995, comma, held that the order passed by the revenue officer in vesting proceeding number 32 by 94 and Devottar case number 4 of 1994 stands quashed. Full stop. In addition, comma, the tribunal directed the BL and LRO Kharagpur 2, Roman 2, to comply with the orders of this court and take all consequential actions within 3 months. Full stop. Next para. Subsequently, comma, according to the appellants, comma, in terms of the said direction, comma, fresh proceedings were initiated under sections 14 within bracket 14 capital T within bracket 5 and 6 of the West Bengal Land Reforms Act 1955. Full stop. Next para. Learned Counsel submits that by the impugned order, comma, the learned tribunal overstepped its jurisdiction in quashing the fresh proceedings on the ground that those are perverse, comma, bad and untenable in law, comma, thereby misinterpreting the earlier order of this court as well as the direction of the tribunal and going beyond the contempt jurisdiction. Who's up next para? Learned Counsel appearing for the respondent number, Mr. Mondal.
For the respondent, writ petitioner.
Only respondent.
Two DTs.
For the respondents, argues that the act of initiation of the subsequent proceedings under the aforesaid provisions was itself contumacious, comma, in the teeth of the direction of the tribunal to comply with the order of this court. Full stop. Next para. However, comma, from a perusal of the order of the tribunal referred to above, comma, we only find that the tribunal directed the BL and LRO Kharagpur 2 to comply with the orders of the High Court and take all consequential action. Full stop. The expression double inverted all consequential actions double inverted close and the true purport of the order of this court in the earlier round of litigation are matters of legal interpretation. Full stop. It is always open to the respondents to challenge the maintainability of the subsequent proceedings, comma, inter alia on the ground that those were not in consonance with the directions of the tribunal and this court. Full stop. However, comma, the scope of contempt is limited to whether the order under contempt was violated or not. Full stop. It is trite law that in the event any interpretation of law is required in respect of the order under contempt, comma, it cannot be said that there was willful and deliberate violation of the order of the court stroke tribunal. Full stop. Thus, comma, in view of the inbuilt ambiguity in the direction of the tribunal to the effect that all consequential actions, quote unquote, all consequential actions were to be taken in terms of the Honorable High Court, comma, it was left to the interpretation of the state authorities as to what was such consequential action. Full stop. The appellants, comma, on their own interpretation of the said judgment, comma, initiated fresh proceedings under sections 14 capital T within bracket 5 and 6 of the 1955 Act Full stop. Although it is arguable whether such proceedings are maintainable in law and stroke or in strict compliance with the earlier order of this court, comma, it was beyond the jurisdiction of the contempt of the tribunal, comma, sitting in contempt jurisdiction, comma, to adjudicate on such issue and to hold that the tribunal's direction was hold that the LRO's action was per se perverse, comma, bad or untenable in the eye of law, and not to quash the same. Full stop. Accordingly, comma, WP LRT 152 of 26 allowed on contest, comma, thereby setting aside the impugned order dated June 23, 2026, passed by the third bench, West Bengal Land Reforms and Tenancy Tribunal in MA 1002 of 2010, within bracket OA 635 of 2004, bracket close, stroke LRTT. Full stop. Next para. It is further noted, and it may be it is further clarified that nothing in this order shall preclude the private respondents from challenging the legality and or maintainability of the fresh proceedings initiated by the BL and LRO Kharagpur Roman 2 under sections 14 capital T within bracket 5 and 6 of the 1955 Act in accordance with law.
Now that will be barred by limitation. That will be barred by limitation. I am to prepare an appeal under section 54.
No, take resort to section 14 if it is available to you, Limitation Act. You should have preferred a challenge, in fact. Contempt is not alternative jurisdiction. So how can we say you bona fide proceeded in a wrong forum?
We understood that since vesting proceeding is quashed, therefore there is no scope for further initiation.
No,
Only
if a proceeding is initiated, you have to challenge its maintainability before the appropriate forum. There are other remedies also before the tribunal also you can go, but you think about that. We won't advise it. Yes.
Sorry, my lord, I was late. I got
No.
stuck, my lord. I'm very sorry.
Yes, please. What is the matter?
My lord, I am for the petitioner. I'm seeking time, my lord. If you fix the matter Monday, please.
Move
My
the
lord.
matter.
My senior is out of this.
You are there. Start the matter.
Yes, I have no brief, my lord. It is instructed to me.
You have a brief.
No. Another brief.
No time.
My lord, just one small thing, my lord. If my lord is of the view that the petitioner will be starting with the matter, my lord, Mr. Chaturvedi, my lord, my senior is in some other court, my lord. Kindly gives a very short passover.
Same to you.
My lord, as much as I want to start, my lord, I am not, my lord, empaneled with the statement. I am just his junior, my lord. I have been instructed.
Junior, my lord. If you fix the matter. I'm a junior, my lord.
Your juniority is different from his juniority. He's not on the panel. He cannot start even if he wants. You are not wanting even to start. What is the matter about? Just open the matter. Open the matter. We don't grant adjournment to juniors who don't have papers. Tell your senior that. Who is your senior?
Masud Karim.
Mr. Masud, come tell Mr. Karim that we have told that we don't permit juniors to take time unless they have the capability to start the matter or have the papers at least. We don't grant adjournment. Sorry.
Allow the short passover, my lord. Please.
Where is Mr.
I'm
Karim?
contacting him.
You will prepare yourself.
No, I will contact my senior, my lord.
No. For that, no possible. You start the matter. Let us see what is the matter. PLLO has been directed to conclude proceeding logically in accordance with law within 6 months. What is wrong in this order?
I'm not aware of this case, my lord. Please, kindly, my lord.
The prayer of
give
the
this matter.
writ petitioner, an adjournment is given. Now, on the prayer of adjournment sought by the writ petitioner, comma, as a last chance to the writ petitioner to argue the matter, the same is adjourned till September 1, 2026. Full stop. It is made clear that in the event the writ petitioner seeks further adjournment or is unrepresented on the returnable date, ex parte orders may be passed in the absence of the writ petitioner. Next.
Grateful.
Give your appearance. Yes, Mr. Bhattacharya.
I am appealing for the state.
Petitioner of the petitioner. He filed an application. Dispute case under section 57B of the West Bengal Estate Acquisition Act. The property is situated in the Purulia district. In the year 2002. But in that 1978.
7B is the bar.
Purulia, initially that came in the year 1964. Initially that was under the Bihar Land Reforms Act.
Yes.
They were on, in the year 1978, two plot, that is plot number 41 and 40 is the tank, that was vested under section 6.1. And that was challenged in this in the year 1979. And there was the interim order also status quo. But that is still in our possession. The matter transferred to the Land Reform Tribunal. The Land Tribunal in 2002 disposed of the matter. We filed a dispute case under 57B3. B3. That was filed by the petitioner of the petitioner. Yes, which one? 57 B3. You got to know? Any dispute?
Yes. Very well.
That is objection. Remember, Lord, in the year 2018, that dispute case was filed, and in that dispute, an application for stay was also filed. In 2018, the petitioner died. There, the petitioner, on coming, he was not aware. He filed an application for being added as a party in that dispute case.
The petitioner died.
Original Aditya Narayan Singh, the predecessor of the petitioner, he died. See, that was kept pending.
We are surprised. The petitioner died. He was not aware of that.
Anyway, my lord.
He could not be.
Sometimes happen also, my lord. Then, my lord,
then you applied for getting yourself implemented.
Implemented.
Right.
Since that was kept pending, came to the tribunal. The tribunal
implemented application itself was kept pending.
Yes, absolutely. The tribunal directed SDL or Jhalda. In the year 2002, at that point of the SDL or Jhalda, that was in the Purulia district. That was curbed most probably 2008 in the Jhalda district. Jhalda. They were directed the SDL or Jhalda to dispose of that application. And initially that appeal was filed that Jhalda Purulia district. He made an inquiry to the Purulia district Land and Names of Purulia. And it appears, as per register, that dispute case was disposed or dismissed. But file is not test out. In the year 2002, the file is not test out. On the basis of that information, the SDL or Jhalda just dismissed our application because no original proceeding was disposed of in the year 2002. But fact remained, entire case record is not test out. Then I challenged that order in the tribunal. The tribunal dismissed my application on the ground that order is available. You don't avail that, only that line that my application has been dismissed. But if the fact, it may be it is an appealable order. But if the record is not tested out, how can I file an application for obtaining certificate copy?
What can the tribunal do, Mr. Bhattacharya? What can the tribunal do?
File on the day, same day that was dismissed.
Why were you waiting for so long? I mean, it is pending from 2002. You filed the implement application in 2002.
No, 2018.
18. Yeah. Till then, the file was there.
Maybe because I am
not sure.
I am not. I pleaded the year 2008 after death of my father that after.
How could you apply? Would that be filed if there was no record?
No, I do not. Just a minute. It has came out in the order of SDR or Jhalda. The file was tested out. I made an inquiry to the office of District Land.
So when you filed the application for implement, then it came out.
Yes.
Oh, you filed an application for implement.
Then it
not
came
being heard. You moved tribunal. Their tribunal sought a report.
Tribunal directed.
In that report, it came out that there was no
the tribunal directed SDR to dispose of my application for additional.
Directed. Then
SDR came out. On searching from the office of the District Land officer.
What would be the effect if that proceeding was not there?
I do not know nothing. That order I have annexed. SDL Jhalda.
There was a previous round of litigation also, you said.
Previous round litigation, only that previous round my application is the tribunal.
Your predecessor?
Predecessor, yes. That year 2002.
Your predecessor's application was dismissed, you said.
No. But
We forgot by now. What happened in the first round of litigation? What was that?
first round of litigation, that was directed me gain liberty to prefer a dispute case
Oh yes,
dispute case.
57B.
Yes.
2.
Then that dispute case was filed.
That dispute case is now missing. That record is
Yes,
missing.
that missing.
What can be done? I mean, we are at a loss.
If I file an application for certificate copy, there is no date. Record is not test out. If the record is test out,
can we think about permitting you to file a fresh dispute case?
No,
There is a time bar now.
But I am submitting my proposal.
If the records are not traced out, what can
they can search out the record. But I request
search out, not found. If the SDLR can't do, your learned friend won't go there.
Only as per register disposed of. Only that line.
What disposed of?
The tribunal, the district landed officer informed the SDLR Jhalda, as per register, it is disposed of 2002. But record is not traceable. Now my learned friend can see what you do. I can apply for certificate copy. That missed case to a 17 of 2002.
See, if the
But
records
date
are
is
not
not there.
traced out, if the your learned friend will obviously say that the records could not be traced out.
Yes.
He cannot say better. What the SDLR said, he has to repeat. So what can be the solution? Let us be solution oriented. If the records are not found, what remedy can you expect?
But if I can
permit you to file a fresh dispute case.
Yes, I can file.
Would that be time barred under any law?
Time barred.
It will be as per direction of court.
But with paper and appeal, that's as per order of the tribunal also.
Where is that order of the tribunal? Let us see.
That order, that is not annexed. It has been mentioned in my application. But kindly see.
Order, do you have a copy?
Copy, that was but method order of tribunal.
Yes.
Yes. But page 22, it has been mentioned.
By which the dispute case was directed to be initiated.
Yes. Entire order has been written, my lord. Entire order is application for stay, filed in the application for application, dispute case, application for stay. Page 22. That one. The read petition being shared, I have got it, my lord.
No, where is that portion which refers to the tribunal's direction?
Just wait. Page 23. As straight for the learner to dispose of the read petition, page 22. Dispose of the read petition with a direction on the applicant to file a dispute case under C of subsection 57B of the West Bengal State Acquisition Act before the subdivision land of Purulia. And if such dispute is filed, the subdivision landed office is directed to admit it by condoning the delay and dispose it of in accordance with the within 1 month from the date of receipt of such dispute. The subdivision land and revenue officer and block land and officer are directed to maintain status quo with regard to the physical possession of the subject land till 7 November 2002. If no appeal is prepared, the stay order shall automatically be vacated. The applicant liberty to pay for further stay order before the appellate authority.
Are you in a position to produce anything regarding that, the record or the order?
It was dismissed in the year 2002. And in 2018, his father died. And thereafter 24, they filed the application for the addition of party. But the SDLR said that when the case is not there, then addition of party, where you will add them?
The question of adding him,
He has applied for addition of party.
What is the order? That is
But Mr. Bhattacharya, we have to be pragmatic also. If you go after 16 years and ask for a certificate copy even, how can you get that? That is not supposed to be retained for so long. Even in a civil suit, it would be destroyed by now. You go after 16 years, then any order, final order will be challenged by approaching after say 25 years. I go and say, no, please give me a copy. I don't find it, so fresh case should be.
But they are now saying this is not traced out. They are not saying.
After 16 years, they may not trace out. The SDLR does not have
as per register, but page 48, there is a finding. SDLR finding, Jhalda.
SDLR that does not have the infrastructure to retain records for more than 16 years. Civil code, exactly. Civil code is it's also destroyed. Much before that.
Civil code
records are destroyed. Those are not courts of records. District courts are not courts of records.
I had a question in
Right, there's a classification in the civil rules and orders itself. Suppose the general.
No, in Alipur court, my client has in 61, that was, this was the operator's certificate copy. I do not know by how.
Your client is resourceful like you.
And what can I do? What I'm saying.
61 certificate copy, something must have been pending in connection with it. Order number 13 or something.
No, I cannot have, because the additional party, according to the SDL orders, there is no.
A final order is passed in 2002. You come up after 18 years, I want to get myself added. It was passed during the when your father was alive.
Father did not disclose thereafter when the.
Your father, you suffer? Father did not disclose.
But it has been stated.
Why should it be disclosed? Everything should not be disclosed to son. Your son knows everything about you.
May I submit one thing? But can I file in a dispute case? Original order was there. Conditions of delay, then we can state the conditions of delay.
Cannot reopen. They say a final order was passed.
But that order, section 6.1 order, that is with us. Section 6.1, that was vested. That order.
Maybe, but your father took out this 57B3 proceeding.
That order, we can.
What is the SDLR report?
Yes.
Page 40.
Page 40, start from page 46.
Mainly
Page 46, and then a relevant portion, page 48.
It has been awaited for that long. ওখানে মারা গেছে তাও 24 সালে করেছে
ঠিক আছে
দেখেছি Your father died in 2018.
18.
So what was he doing between 2002 and 2018?
But they are still in possession. They did not know this mission inquiry. Somebody said BLO office, it is vested.
You cannot just come up taking advantage of your father's demise and just.
But I can
understand. You're for the father?
No.
Assisting him. Can you see page 48? Page 48. It is further significant to mention. Against memo number such and such of this office regarding information of said case 17/2002, it has been communicated by the office of the district land and office of Purulia by number such and 2028.
It's in the register, so.
Register.
Yes, official acts. Presumption of correctness.
Then if I go, but it's a remedy is a paper and appeal. It has been dismissed. Liberty was not given. I can apply for certificate copy. But for the sake of argument. For the sake of argument. But limitation period, that will be.
Cannot come up and, unless it's a court of records under Article 215.
Yes.
You cannot come up and apply for a certificate copy and legitimize your non-existent right at any point of time. Every office has its tenure of retaining records, Mr. Bhattacharya. After 16 years, not any civil court retains its records if it is disposed of. If something is pending, yes. Order number 13 pending or something pending, execution pending, then the records are retained. Otherwise, no. Why should it be retained?
Admittedly, the your loss is not section 10(2). That is that was not also that is still in our possession. Still in our.
What will be the consequence? Yes.
Still in our possession. That is
what is the relief you sought before the tribunal?
Tribunal.
You said that you sought a direction to dispose of that.
Yes.
So that was previously passed.
No, that was previously.
No, page 22, what you submitted before us, there's already a appeal was you are permitted to prefer an appeal.
Yes.
So your father preferred an appeal actually.
Yes, but tribunal I prayed for to direct the respondent SDRO Jhalda Purulia.
Or to take up your this substitution application.
No. The tribunal I prayed for.
Yes, what did you pray?
To direct the respondent SDRO Jhalda to withdraw, record and set aside the order impugned such as dated 5th December 2025. To direct the respondent appeal to submission land officer to dispose of the application for additional party. Only that was paid for. Now, according to SGR, if there is no main matter that has been disposed of according to report of the SGR, that has been infectious automatically. I cannot.
Not infructuous. The final order was passed in 2002. How can you blame the state for not being able to produce the records
Now, facts remain, it is not traceable. That was not informed also then.
2025, 2002, 2025, there 23 years have gone by.
A state did not take any step also. With
What steps? An order is passed against the predecessor.
No, I not that. But there is a tank, two tank, that is in our possession. They are
we are meeting your grievance. We are directing the state to immediately take action on this. That's your grievance, Mr. Bhattacharya. We are
No, that is not being
right now.
What I am submitting, if you lost it,
we are directing the state
can
to
you
take.
confirm you lost it? Can you file a dispute at 57B3? That is my
Dispute was filed by your father. You admit that. You
yes.
seek implement there after the demise of your father in 2018. SDLR says it was already disposed.
Case number also have given.
Disposed, he gives reference to the memo number also.
That is 2025. That is 2025. And SDO Jhala came to know after making inquiry to the officer to the Purulia. He was not aware that was disposed of.
Date of dismissal also could not be given because the records are not there.
No, could not be disclosed. But
in the
register, what I am saying.
In the register, it was
mentioned the register. Date must be there.
Can you produce a copy of the register? We'll directly.
That was produced before the SDLR.
We want to see the register.
Yes. But before tribunal, that was not produced.
Page 48, last paragraph.
We want to see. We want to see. We'll request you to produce the. You can't request you. We'll direct your client to produce it. Yes. The predicament before the predicament in the present case is peculiar. Stop. Initially, comma, on a previous in a previous round of litigation, comma, the tribunal, the West Bengal Land Reforms and Tenancy Tribunal, had passed an order on September 9, 2002, at the behest of the writ petitioner's predecessor in interest, to the effect that the applicant, comma, that is the predecessor of the present writ petitioner, comma, would file a dispute under subsection 3 of section 57 capital B of the West Bengal Estates Acquisition Act 1953 before the subdivisional land and land reforms officer, comma, Purulia. And if such dispute is filed, comma, the SDLR was directed to admit it by condoning the delay and dispose it of in accordance with law within 1 month from the date of receipt of the dispute. Full stop. Next para. Subsequently, comma, a proceeding was initiated by the predecessor in interest of the writ petitioner in terms of the said order. Full stop. On the demise of the petitioner's predecessor in the year 2018, comma, the writ petitioner applied for being impleaded in the said dispute case, comma, initiated in the year 2002 itself. Full stop. Next para. However, comma, since the said application was kept pending by the concerned SDLRO, comma, the writ petitioner approached the tribunal upon which the tribunal directed such application to be disposed of. Yes. Full stop. When the matter went back to the SDLRO, comma, by an order dated December 5, 2025, comma, the SDLRO took note of memo number 388/SDL and LRO/JLD/25 dated July 17, 2025 of his office regarding information of the said dispute case bearing number 17 of 2002. It was further recorded that it had been communicated by the office of the District Land and Land Reforms Officer, comma, Purulia, vide memo number V-3705/cell/CELL/25 dated August 28, 2025 that the said case was dismissed, comma, which was found reflected in the relevant register of the DL and LRO, comma, Purulia. It was further informed that the original case record could not be traced out by the said office. On the premise of such memorandum, comma, the SDLRO disposed of the application of the writ petitioner on the ground that in view of the original proceeding having already been disposed of, comma, the petitioner's application for addition of parties has been rendered infructuous. Full stop. Next para. When the writ petitioner challenged such order of the SDLRO before the tribunal, comma, the learned tribunal, comma, by the impugned order dated February 27, 2026, comma, came to the conclusion that it is evident that the main matter has been disposed of on the strength of section 57 capital P within bracket 3 of the 1953 Act, which is an appealable order. Thus, comma, it was held that the original application before the tribunal was not maintainable, comma, being barred by section 10 within bracket 3 within bracket small a of the West Bengal Land Reforms and Tenancy Tribunal Act 1997. So next parallel, counsel for the petitioner argues that since the records themselves have been found to be missing, comma, there is no scope of preferring any appeal against the order passed in the dispute case, comma, since no certified copy of the impugned order can also be obtained in the absence of the records. Full stop. Next para. Thus, comma, it is submitted that the writ petitioner ought to be permitted to initiate a fresh proceeding under section 57 capital B within bracket 3 of the 1953 Act. Full stop. Next parallel, counsel appearing for the state opposes such prayer and contends that the SDL and LRO placed reliance on the report issued by the DL and LRO Purulia, which in turn, comma, relied on the relevant page of the register maintained in the said office, which was annexed to the report dated August 28, 2025, received from the office of the DL and LRO. Full stop. Next para. Thus, comma, it is contended that since the concerned register reflects that the case was disposed of, comma, a presumption of correctness should be attached to the said register. Full stop. Next para. In any event, comma, it is submitted that since the SDLRO was not a court of records, comma, the upon the writ petitioner approaching after 16 long years from the disposal of the said case in the year 2002, comma, it would not be possible in any event for the records to be traced out. So thus, comma, it is argued that undue advantage ought not to be given to the writ petitioner of his own inaction. So next para, it transpires prima facie that there is no explanation as to what steps were taken by the predecessor in interest of the writ petitioner with regard to the dispute case from the year 2002, comma, when it was initiated, till 2018, comma, when he met his demise. Full stop. Next para, a right which has already been foregone by the predecessor in interest of the writ petitioner cannot be said to be revived merely because the petitioner renewed his efforts to rejuvenate a dead proceeding, comma, which was already disposed of long back. Full stop. Next para, be that as it may, comma, in order to ascertain as to how far the presumption of correctness can be attached to the concerned register on which the DL and LRO relied, comma, we direct the state to produce the said register on the returnable date for inspection by the court. Full stop. Next para. Let the matter be listed next on how much time do you require? Purulia. The matter shall next be listed on September 8, 2026 for passing further orders. 8. For passing further orders and for production of the aforesaid register in its original. register or its extracts in original. It in.
Well, I'm for the respondent.
Respondent. We're giving the last chance. None appears for the writ petition at the time of call, although the respondents, you are for the state.
Yes.
Respondent state is represented to what? Do you have a designation?
AGP.
Although learned AGP appears for the state. Full stop. Next para. As a last chance to the writ petitioners to move the matter, the same is writ petitioner to move the matter, comma. The same is adjourned for the day. Full stop. In the event the writ petitioner remains absent on the returnable date, ex parte orders may be passed in the absence of the writ.
Sorry, my lord, in item 22, I came late. I got stuck in court number 8.
Pass similar orders against you?
No, my lord. Lordship had allowed my appeal.
Appeal. You can recall that if you want.
No.
Whatever you want. Your name won't be recorded.
No problem. The state
Come a
has.
bit late. Yes.
Yes.
Next.
Item number 25. 25, I'm for the petition.
Item number 25 appear for the petitioner.
Sir?
Item number 25 appear for the petitioner, Your Lordship.
You are muted.
I have unmuted.
It's fine. Now it's fine. Yes. Yes. What is the
Your
matter?
Your Lordship, not much remains to be said in this matter, inasmuch the order impugned in this writ petition has already been set aside by Your Lordship in an earlier proceeding. I request my learned friend to hand over a copy of the orders. It is WPLRT 138 of 2026.
The self-same order.
Self-same order. Self-same order. We are appearing for one of the parties who has not been imputed as a party to the proceeding.
So this is infructuous then. I mean,
it is infructuous. However, Your Lordship had been pleased to direct the private respondent to implicate the writ petitioners as parties before the tribunal. We pray for similar prayers, Your Lordship, because none of us had been imputed as parties in the proceeding before the learned tribunal. If Your Lordship kindly takes a look at paragraph number 8, page 3 of the order of the order that has been handed. Yes, Your Lordship.
Oh, this one.
Yes, Your Lordship.
Give us 2 minutes, Mr.
Yep.
Despite service, none appears for the respondents. Affidavit of service filed to be kept on record. Next para. The counsel appearing for the writ petitioners submits that the writ petitioners are similarly placed as those in WP LRT 138 of 2026, which was disposed of by this court by an order dated August 10, 2026. Full stop. By the said order, comma, the impugned order, the self-same impugned order, which is assailed in the present writ petition, was set aside and the matter was remanded to the tribunal with a direction on the private respondent to implead the writ petitioners therein as parties to the original application. Full stop. Upon such impleadment, comma, notice was also directed to be served on the writ petitioners and an opportunity of hearing to be given to both sides, and thereafter to decide the original application bearing OA 2560 of 2025 bracket LRTT afresh on merits. So that original application is still pending, we hope.
It is not. It has been disposed of by the tribunal. Assailing the judge final order, we have come up before this honorable court.
No, then how can we reopen this?
No, I beg your lordship's pardon.
No, we are saying that by your previous order, we had directed
Yes.
OA 2560 of 2025 to be heard afresh.
Yes, your lordships.
Oh, that had been disposed of in the previous.
That had been yes, your lordship.
So after remand, that is pending. That is what we are asking.
After remand, it has to be heard afresh, your lordship.
It has not yet been disposed of after remand.
No.
So we find from the order dated judgment dated August 10, 2026, passed in WP LRT 138 of 2026, that the present writ petitioners are similarly placed as the petitioners therein and have several issues to raise in respect of the subject matter of OA 2560 of 2025 bracket LRTT. Husab, since we have already directed the said original application to be heard afresh on merits, comma, there is no reason as to similar opportunity as that given to the writ petitioners in WPLRT 138 of 2026 should be denied to the present writ petitioners. Husab, accordingly, WPLRT 156 of 2026 is disposed of in the light of the observations made in the judgment dated August 10, 2026, passed in WPLRT 138 of 2026, and directing the private respondent to implead the present writ petitioners as parties to the said original application. Upon such impleadment, comma, and notice being served on the present writ petitioners, comma, an opportunity of hearing shall be given to the writ petitioners as well as the other parties to the said original application. Thereafter, the learned tribunal shall proceed to decide OA number 2560 of 2025 within bracket LRTT afresh on its merits. No orders to cause urgency. Thank you.
Grateful, your lordships. Grateful.
You are appearing it can't be decided in 1 minute.
No, this is a put up petition.
The petition?
Yes.
What do you mean by that?
Prepondering of debt before electing. I mean, I'm opposing it.
Lordship.
You're opposing this?
Oh, dear. Lordship, I'll have to see that the plots in question purchased by the predecessor of the petitioners in 1938 from the then Governor General in Council. Land is situated in Dum cantonment area. There is a large chunk of military lands. Now it has not been segregated. What are the private lands? What are the military lands occupied? Now only in 2021, it has been issued by a memo that private landowners shall apply for mutation. Pursuant to this notification dated 16th August 2021, we have filed a mutation application by annexing the deed of 1938. On 22nd September 2021. 22nd September 2021, we have filed mutation application. Now the next notification issued by the Naban on 31st July 2023, you will have to conclude the proceedings of mutation, all the private landowners. Now, they have nothing to do with this. We have approached the tribunal, being OA number 2076 of 2025, and the tribunal directed that the mutation application shall be disposed of within 6 months. Your lordships can have to see the order at page 19. 18. By order dated 21st August 2025, the application has been remanded to the tribunal to dispose it of within 6 months. Now we have communicated this order to the concerned authority. They failed to comply the order. We have filed a contempt application being MA number 973 of 2026. Now this will appear before the tribunal on 14th July 2026 at page 20. Now the record is not available. call for the reports from the collector, and the date has been posted on 14th July 2027.
July, January.
January. Now, if your lordships kindly have to see, first of all, the language of Article 323B 3F.
Now it has a constitutional.
Lordships kindly have to see.
You got to apply your minds on the constitution.
Article 323B subclause 3F contains such supplemental, incidental, and consequential provision, including provisions as to fees, as the appropriate legislation may deem necessary for the effective functioning of and for the speedy disposal of the case by the enforcement of the order of such tribunal. Now, if your lordships kindly to see the rule 72 of the LR manual.
Come back on the next day. This is some hearing.
Plus,
affidavit of service filed to be kept on record. First of all, although the hearing is commenced, the same cannot be concluded due to paucity of time. Let the matter be listed next on September 1, 2026.
Plus.